Hmm. ಏನಾಗಿದೆ ಇದು? Yes, you take ಇದು ಆಗಿದೆ. Yeah, have you taken notice? Huh? ಇವರು correct ಅವರು ಹೇಳಿ ಅದು. Yes, regarding maintainability. Then additional SPP prays for time to make a submission regarding maintainability of the criminal petition system. Yes, you have to make submission. Yes, next.
Serial number 7, Rajaram Suryambal, BS Prasad.
Who filed the application? Appellant filed. 2023 in the application pending ಇದೆ. Counsel for the appellant raised for time. The appeal is of the year 2017. Then a counsel for the appellant filed IA-1 of 2023 seeking early hearing. The appeal is already admitted. Even though the court is ready to hear the arguments and to dispose of the appeal, then the counsel for the appellant is absent. He is not ready to address the argument. Hence, IA-1 of 2023 is dismissed. List for final hearing. Next.
Serial number 8, Nanjundagowda MR. Nanjundagowda.
ಕೊಡಿ. Then he was on bail. Notice ಆಗಿಲ್ಲ. ಅಪೀಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. Sole respondent. Yes. So, counsel for the appellant is absent, no representation. The appeal is of the year 2021. IA-1 of 2021 is pending since 4 years. Order sheet dated 12/12/2022 discloses that the appeal was admitted. However, consideration of IA-1 of 2021 is deferred. Next, additional SPP submits that the offence is under section 6 of POCSO Act. Is to 10 or 20. And the appellant was sentenced to undergo imprisonment for 10 years. Looking to the nature and seriousness of the offence, the appellant is not entitled for the suspension of sentence. Since the appellant is in custody since 4 years, counsel for the appellant is directed to address his arguments on merits. As the trial court record is already received, hence IA-1 of 2021 is dismissed. List for final hearing. Yes.
Serial number 9, Tala Ismail.
Why all these 2 years you have not pressed? Order sheet ಕೊಡಿ. Yes, he was on bail. Third Learned Counsel for the appellant on A1 of 2023 suspension of sentence and for release of the accused on bail. The format of he was on bail during so and so. IA1 2023 is allowed. Order of sentence. Third so and so. Learned Counsel for the appellant and learned additional SPP on admission, satisfied with the grounds made out in the appeal. Appeal is admitted. Yes, for final hearing. Yes.
Serial number 10, Sumant L. Bharadwaj.
In serial number 10, 9 ನಲ್ಲಿ ಫಸ್ಟಿಗೆ ಅದನ್ನ ಹಾಕೊಳ್ಳಿ. So and so submits that he has filed wakalat for the appellant with no objection from the earlier counsel. Office is directed to verify and show the name of so and so, deleting the name of so and so. ಅದಾದ್ಮೇಲೆ ಹರಡು. Yes. Yes.
10, Sumant L. Bharadwaj.
Counsel for the appellant is absent, no representation. Next.
Serial number 11, Sheikh Badigar.
Yes, what is it? Heard ಅದೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. IA1 IA2 of 2024 seeking suspension of sentence and releasing the appellant on bail. IA is allowed. Order of sentence suspended. Accused is accused R ಅಂತ ಇರ್ಬೇಕು ನೋಡಿ. ನೋಡ್ಕೊಂಡು ಹಾಕ್ತೀವಿ. Order to be released on bail. They were on bail during trial. There is no allegation of misuse. IA2 of 2025 4 is allowed. Argue on merits. Sir, already conviction ಆಗಿದೆ. Only way out is to address the arguments. Admit ಆಗಿದೆ final hearing. Argue on merits. ಮತ್ತೇನ್ ಮಾಡಬೇಕು? Hearing, if you are ready, I will post it somewhere. Next time, ಮುಂದಕ್ಕೆ. Yes. For final hearing.
Serial number 12, Avinash DB.
Order sheet ಕೊಡಿ. ಏನ್ ಕಾಪಿ? He was on bail. When he was ordered to be released on bail, (202)
In 2 weeks.
Yes, what is it? He is accused number 1. What about delay? That is not the automatic, automatically it will not be allowed, sir. If he is in, ಅದನ್ನ ಮತ್ತೆ ನಾನು ಅದನ್ನು ಹೇಳಲ್ಲ ಸರ್. If he is in custody, he will be more secured, more chances of getting the legal services, unlike the accused outside. Casually custody in ಕೂಡಲೇ ಅಲೋ ಆಗುವಂಥದ್ದು ಐ ಡೋಂಟ್ ಥಿಂಕ್ ಸೊ. Learned counsel for the appellant and learned additional SPP on IA number 1 of 2025. There is delay of 440 days. Huh? Yes, but earlier he was on bail. But there is an inordinate delay, 440 days delay, when he was in custody. ಏನಾಯ್ತು? In preferring the appeal, the only ground urged by the learned counsel for the appellant is that the appellant was in custody and therefore he could not prefer the appeal. ಅದು ಆ ಸಿಸ್ಟಮ್ ಇನ್ ಪ್ಲೇಸ್ ಅಂತ ಪಾರ ಇದೆ ನೋಡಿ, ಅದು ಹಾಕೊಳ್ಳಿ. In spite of this, all these checks and balance and the system in place, the contention of the appellant that since he was in custody, he could not prefer an appeal cannot be accepted. Hence, the counsel for the appellant is directed to find out the true reasons for the delay in preferring the appeal and to make his submission on IA1 of 2025 on the next date of hearing. Next one, IA2 of 2025 is filed seeking suspension of sentence and for bail. Even though IA1 of 2025 is kept pending for consideration, it is noticed that the appellant accused number 1 was on bail during the trial and he was taken to custody on the date of his conviction. And since then he is in judicial custody. Considering the same, I am of the opinion that the appellant may be ordered to be enlarged on bail subject to conditions by suspending the sentence. Accordingly, A2 of 2025 is allowed. So you find out the correct true reason for the delay and make your submission. ಅವ್ರು ಏನೇ ಇರಲಿ, the moment he is in custody, there is a system in place. Penal advocates are visiting the jail and they are assisting the convicts. Why that is not being done? Please verify and make your submission. Yes, there may be lapses in the system itself, so that you have to bring it to the notice of the court. Yes.
Serial number 13, Nishit Kumar Shetty.
Father is? ಅದೇ ಅದು ಮೆಕ್ಯಾನಿಕಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಸರ್. ಕಸ್ಟಡಿ ಅಂದ ಕೂಡಲೇ ಅಲೋ ಅಂತ, ವೆರಿ ಡೇಂಜರಸ್ ಸಿಚುವೇಶನ್ ವಿ ಆರ್ ಡೂಯಿಂಗ್. Yes, the fault is on our part. We are accepting that. See, please understand the system. There is a system in place, and when the system is in place, if we are to say that there is 1 year delay, 2 years delay, since the accused could not contact his family members, accused could not engage the services of an advocate, mechanically, if we accept that, what should happen to the system? We do not know how the system is working. It is great disservice to the system itself. Hmm. Hmm. Is it the affidavit filed by your third learned counsel for the appellant and learned additional SPP on IA number 1 of 2025 and the fresh affidavit of the father of the appellant sworn to on 28/6/2025. Says is satisfied with the grounds urged in the affidavit for the delay of 195 days in preferring the appeal. IA 1 of 2025 is allowed. Delay is condoned. Hereafter, don't accept such reasons mechanically. You have to do some research. Yes, really there. He was unveiled. Heard so and so on IA 2 of 2025, seeking suspension of sentence and releasing the appellant on bail. He was on bail during the format of IA 2 of 2025 is allowed. Admit ಆಗಿದೆ. ಇಲ್ಲ. Notice ಹೋಗ್ಬೇಕಲ್ಲ ಅವರಿಗೆ ಆಗಿದೆ. Yes, heard learned counsel for the appellant learned additional SPP on admission. Peruse the materials on record in the light of the grounds urged in the memorandum of appeal. Satisfied with the same, appeal is admitted. Call for trial court records. List of for final hearing. Appeal is admitted. ಯಾವುದ್ರಲ್ಲಿ ಸರ್ ನೀವು ಅದೊಂದು ಪ್ರಾಕ್ಟೀಸ್ ಆಗಿಬಿಟ್ಟಿದೆ. ನೀವು ಅದನ್ನೇ ಮಾಡಿದ್ದೀರಿ. ನಮ್ಮ ಮೈಂಡ್ ಸೆಟ್ಟು ಹಾಗೆ ಈಸ್ ಇನ್ ಕಸ್ಟಡಿ ಸೊ ಕಂಡೋನ್ ವಾಟ್ ಎವರ್ ಮೇ ಬಿ ದಿ ನಂಬರ್ ಆಫ್ ವಾಟ್ ಶುಡ್ ಹ್ಯಾಪನ್ ಟು ದ ಸಿಸ್ಟಮ್. So it gives an impression there is no system in place. The moment the accused is in custody, he is helpless. That cannot be. ಅಷ್ಟೇ ನಮ್ಮ ಆಂಗ್ಸೈಟಿ ಅಷ್ಟೇ. Mechanically that should not be accepted. Yes, ಅಷ್ಟೇ ಅದಷ್ಟೇ to draw the attention of the advocates I am doing this. And it is a lesson for us also. It should not be accepted mechanically. ಅಷ್ಟೇ. Yes.
Serial number 14, Dharanisha, connected matter, Vasudeva Iyengar.
File a better affidavit. Counsel for the appellant prays for time to file better affidavit in support of IA 1 of 2025. ಅದಕ್ಕಿಂತ ಮೊದಲು ಅದನ್ನು ಹಾಕೊಳ್ಳಿ. Third learned counsel for the appellant and learned additional SPP on IA 1 of 2025 seeking condonation of delay of 689 days. ಅದೆಲ್ಲ ಬರೆದಿದ್ದೀವ ಮೊದಲಿನ ಇದರಲ್ಲಿ ಇಲ್ಲಲ್ಲ. It is stated that since the accused was in custody, he could not prefer an appeal in time. ಅದಾದ್ಮೇಲೆ ಅದನ್ನೆಲ್ಲ ಹಾಕೊಳ್ಳಿ. Learned counsel for the appellant prays for time to file better affidavit explaining the delay. ಎರಡರಲ್ಲೂ ಕೂಡ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ನಲ್ಲೂ ಸೇಮ್. Yes, file better affidavit. Issue notice to respondent. ಮತ್ತು ಕನೆಕ್ಟೆಡ್ನಲ್ಲಿ ಆಗಿದಲ್ಲ. Issue notice where release 14 ನಲ್ಲಿ. Yes. Next.
Serial number 15, Nishant SK.
He was on bail. Yes. Not referred to in the judgment. Whether it is stated he was on bail. Heard learned counsel for the appellant and learned additional SPP on IA numbers 1 and 2 of 2025 seeking condonation of delay of 37 days in preferring the appeal and for suspension of sentence and to release the appellant on bail. For the reasons stated in the memorandum of appeal accompanying IA 1 of 2025, delay or for the reasons stated in so and so, IA 1 of 2025 is allowed. Delay of 37 days in preferring the appeal is condoned. Next, the appellant was on bail at IA 2 of 2025 is allowed, subject to conditions. Next, heard so and so on admission, satisfied at Lahaki. Appeal is admitted. Call for trial court records list for final hearing.
Final hearing, serial number 16. Nitin R.
Counsel for the appellant prays for time. As per order dated 2/2/2023, it was suggested to implead the informant complainant as party. Till today, no such applications are filed. Hence, it is taken that the complainant respondent is not made party in the appeal. Next, appeal is of the year 2021. The appellant is in custody since more than 8 years. I do not find any reason to adjourn the matter. Counsel has praised for time fully. I do not find any reason to adjourn the matter. However, to afford one more opportunity this time. Next, finally post. Next.
Serial number 17. Saravana S. Connected matter Satyanarayana Estate.
Yes. Accused number? A1. He was convicted
for the offences under section 306 and 498A. And sentenced.
What about 2 and 3?
They have been acquitted.
And the second one is the appeal by the state.
Second appeal by the state, but insofar as the inadequate sentence for A1, but they do not challenge the acquittal of A20. So the state also does not challenge the acquittal of the other offences insofar as A1 is concerned. It is only the inadequacy of sentence for which the state has argued.
Acquittal of A1 for which offence?
Acquitted for the offence under 304B, 302, and 3 and 4 of the dowry prohibition. The charges were framed Kindly have a look at the charges. So, page 48. Initially, my lord, the complaint was filed against 4 accused, including the relative. But in the charge sheet that was filed, my lord, the 4th accused was dropped.
Date of marriage.
The date of marriage is 9th November 2009.
Date of incident.
The date of the incident is 19th August 2010 between 3 p.m. and 5 p.m.
Nine months.
Please.
Within 9 months.
Please.
How she died?
So she committed suicide.
How?
In the
Why
marital house.
Why 302 was invoked?
Not relying upon a judgment, my lord, wherein it says where it is 304E. That is what is, my lord, referred to in the judgment, my lord.
No, charge was not framed for that.
Charge was framed, my lord, the 4th charge.
As per charge sheet, what is the offense?
My lord, as per the charge sheet, it is 304B and 498A of the IPC and 3 and 4 of the Royal DPI. For charge 4,
Who is the complainant?
the complainant is the father of the deceased, father-in-law of the
How many witnesses are examined?
Lord, in all 22 witnesses have been examined.
Exhibit.
And Lord, 49 exhibits have been examined.
51.
I'm sorry, 51. 53.
53 now.
53.
Yes.
Lord, there are 3
Yes.
printouts.
Yes.
And Lord, 17
Emotion.
objects.
Yes. Who is PW1?
Lord, PW1, Lord, is a friend of the first informant. And Lord, a witness to the inquest.
Inquest measure is exhibit.
Exhibit P1.
Yes. Then
Lord, PW2 is Via Shweta, the elder sister of the deceased.
yes. Then
Lord, PW3, 4, 5, and 6 are the police officials.
what they has done?
My lord, one PW3, my lord, claims to have arrested the accused. Numbers 1, 2, 3. Lord, PW4, my lord, who has registered the FIR. Lord, PW
FIR is exhibit.
exhibit P35.
First information.
And first information is exhibit P12.
Then 5.
Please,
5. PW5.
please, PW5. Lord, is the one who refers the materials present. PW6.
6. Refers andre he's the investigating. No, whether he is the investigating officer, only carrier of the article. Carrier
Police
of
constable, WPC.
then 6.
Lord, I'm sorry, Lord. PW5, my lord, is collected the bank details of the deceased from corporation bank. And PW6, submitted the documents for FSL examination to the candidate. PW7 is the mother of the deceased. PW8 is the father and the first informant.
Then
PW9 is the friend of the father.
yes. Then
PW10 Mahadevamma is the neighbor
of
the father, the parents, and a friend of the mother. PW11 is the maternal uncle of the deceased. PW12 is a friend and a mother witness.
which mother?
The recovery of the death note and the spot. The death note is exhibit 11.
It was recovered from the house.
They claim to have recovered from the house.
Mazar is exhibit.
Mother is exhibit 13.
PW13.
PW13 is again a friend of CW1.
Then 14.
PW14 is a friend of the deceased. PW15, my lord, is again a friend of CW1 and a witness to the mother, exhibit P28. So with regard to the admitted writings of the deceased. So PW16 is the PMO.
Report is.
Please, sir.
PM report is exhibit.
PM report is exhibit P29.
Cause of death.
Cause of death is asphyxia as a result of accident.
Then
PW17, my lord, is the Tahsildar who conducts the inquest. Exhibit P1. Upon a request made by the police, the request is submitted as exhibit P1.
Then
PW18 is the manager of Corporation Bank. Who submits the account opening form.
why this?
But perhaps not for referring it to the physical examination.
Then
PW19 is the principal of MES Institute of Management. So it produces the educational credentials of the deceased.
how that is relevant?
But for referring it.
Again, handwriting.
Yes, please.
Then PW.
PW20 is the investigating officer. 21 is also the investigating officer.
Who is the first investigating officer?
Please, sir.
Who is the first investigation?
The first investigation is
20.
Yes. And
P21 is filed the charge sheet.
21 is who has done the major investigation and submitted the findings.
Then 22.
22 is the FSL officer.
Report.
The FSL report is exhibit P49.
ಏನು ನೆಗೆಟಿವ್ ಇದೆಯಾ? ನೆಗೆಟಿವ್ ರಿಪೋರ್ಟ್?
It is a positive.
ಪಾಸಿಟಿವ್
It
ಯಾವುದಕ್ಕೆ?
says that the report is in the handwriting of
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್.
of the deceased.
For the material witnesses,
Lord,
PW2,
there are no independent witnesses.
PW,
All are the witnesses. Lord, PW1 speaks about the incident. PW2,
no, PW1 also speaks about
he
incident.
speaks about Lord, the marriage being performed. What
Marriage
was
is-
given in marriage.
it
But
may-
it does not speak. Lord, all these witnesses basically Lord, are hearsay witnesses. Lord, wherein they speak, the source of their information is the deceased.
No, elder sister, PW2,
Lord, she also speaks about what the deceased will to tell.
yes. Then father, mother,
Father, mother, my Lord, PW7 and 8.
8.
They also speak about what the deceased will to tell.
No, regarding incident.
Lord, with
Naturally.
regard to the incident,
Hmm.
Lord, the sister claims that there was a call
Hmm.
made when, and Lord, as per the inquest, Lord, she is the last person to have heard the deceased when she was alive.
Oh, PW2.
PW2.
Huh.
Lord, in that telephone conversation, Lord, as narrated by her, Lord, there was nothing, Lord, which would indicate that she is likely to commit suicide. But she says that her voice was feeble and she was not in a position to speak. That is all that she speaks.
Hmm.
Lord, the entire case, if my Lord would kindly turn to exhibit P12, my Lord, the complaint.
P11, P11 death note.
P11 is the death note. Lord, that was found, my Lord, subsequent to the filing of the first information. Exhibit P12 at page 4, my Lord.
Hmm.
So it speaks about the marriage being performed, whatever was given as during the course of marriage. Lord, they speak about the demand of 4 lakhs, 1.5 months after marriage. Lord, at the second paragraph.
But he is acquitted for offense under 3 and 4.
Lord, with regard to Lord 306, Lord, the death note, Lord, may kindly have a look at exhibit P11.
No, see, in exhibit P12 there is highlight regarding demand and acceptance of dowry.
Please,
That is the
there is no
highlight.
mention, there is no mention of any other reason. Lord, in the evidence, Lord, they reside. All the witnesses say that what was given to
But
the
there
bride
is-
and groom was not as per the demand.
But there is reference to the ill treatment meted to her.
Ill treatment with regard to dowry, Lord, is the first information. One and a half months later, Lord, for the purchase of a car, they were demanding 4 lakhs. They were ill treating her. Lord, on 17/8/2010, when he goes to call her home, Lord, they do not permit her. Lord, and on 19/8/2010, at around 5 p.m., he received a call from A1 stating that your daughter has locked herself inside and she's not opening the door. He comes at 5:30 and they break open the door and they find the dead body of the deceased. What is the first information?
Hmm.
Lord, may kindly have a look at the inquest. So this inquest was conducted on 20th between 12 noon and 2 p.m. Lord, the three witnesses to this incident are PW1, CW7, and CW13. Lord, all these three witnesses are interested. But Lord, they were shown as witnesses.
No,
Lord, the statement of this.
see, when they offense under 498A, dowry prohibition,
No, I'm not.
naturally, the family members will be the witnesses. We cannot accept.
Lord, I'm not on that. Lord, although they are witnesses, Lord, under column 10 and 11, Lord, that statement is also being recorded. So either I can be a witness to an inquest or my statement. I cannot do a dual job. So Lord, this PW1, his statement is also recorded under column 11 by the Tehsildar. Lord, along with this PW1, Lord, the statement of Lord, PW2 is also recorded. Lord, why it would assume importance is, Lord, this is recorded on 20th. And the entire allegations, Lord, are revolving, Lord, as that is the first information report. Lord, on 19th, they claim that this death note was recovered as per the spot master. Wherein, in the death note, there is no reference with any harassment with relation to dowry or demand.
No, date of incident itself on 19th.
Please, madam.
19th is the date of incident.
19th is the date of incident. 20th is the inquest.
20th.
20th is the inquest. Inquest is recorded on 20th August.
First information 19th.
First information on 19th August. 19th August, my lord,
The death note was recovered
on 19th August, as per Exhibit P13.
No, recovered on
19th August.
On the date of incident.
On the date of incident.
So at the time of inquest, the death note was
already there. And Lord, the witness is the father. In this spot master.
Then what is the reason stated in the death note?
Lord, she suspected that the accused number 1 was having an affair with one Harsha, a colleague of his.
Yes.
Lord, in fact, if my lord would kindly peruse Exhibit P13, Lord, 1 to 4 Lord, was on the body of the deceased. Item numbers 1 to 4, the Lord, page 3 of Exhibit P13.
P13, you know. What is 13?
Lord, that is the spot some recovery marker. Lord, this Exhibit P13 was on 19/8/2010. Lord, between 7:15 p.m. and 8:15 p.m. Lord, page 3, Lord, item numbers 1 to 4 are all on the body. Then 5, 6, 7, 8 were near the chair on the bed sheet, near the table, near the chair. Manchada ಮೇಲೆ rolling the chair in a pocket. But then this 9 and 10 shows to have been added. Subsequently. Because
But that was found to be in her handwriting as per the FSL report.
Why I say that it is a subsequent, but I demonstrated before your talking. But when kindly turn to this PF that was drawn.
No, if see, you cannot say that it is a concocted letter.
The defense taken by the trial court advocate is that the handwriting of both the sisters is and that this is a subsequent insertion.
Whether you have taken any admitted handwriting of the sister? No.
The investigation that was on. What the doctor says. I'm sorry, what the FSL officer, when he was being cross-examined, suggestions have been put to him by showing the signature of PW2 in the deposition as well as in the inquest. What he says is I cannot say whether it is safe. Because it has to be examined is what he says. That is the only suggestion with regard to this. Why I say that this entire the case of the prosecution is that the husband and in-laws were targeting her or subjecting her to cruelty only for the purpose of dowry. There is no other reason which could be found either in the FIR or in the inquest.
One ನಿಮಿಷ charge ನೋಡು.
Please. Charge 3 and 4. But 1 and 2 is with regard to the dowry. Demand and acceptance, section 3 and 4. Charge 3 that you accused persons in the house situated in number so and so, and you accused number 1 being the husband used to talk with your colleague CW10 Harsha, and you accused numbers 2 and 3 being parents of the deceased with common intention subjected her to cruelty to bring dowry and thereby committed an offense under section 493. And the fourth charge that the deceased being your wife and daughter-in-law, respectively, unable to bear your cruelty and harassment, subjected by all of you soon before her death, in connection with demand of dowry, committed suicide on 19 May 2010 between 3 p.m. and 5 p.m. in the house at home, and thereby you are. But Exhibit P11 does not make any mention of any harassment related to dowry or a demand of anything. And the charge against A1 for 498A is not a demand of dowry, that you should talk with this girl Harsha. Under 498A.
Yes.
But this girl Harsha has not been examined by the prosecution.
Even if examine whether she will support.
She would not have supported. She would not have. The charge against me for 498A is that I had an affair. It is not even I had an affair. That I should talk to this girl.
Yes.
But for a moment, Lord, in the absence, Lord, even if, Lord, although there is no evidence left to this aspect, even if it is proved to be true, Lord, whether it would come within the explanation, one or two, Lord, if she has committed suicide, yes. But whether my allegation is of such an extent that it is driven her to commit suicide, she's not talking with the police, whether that could be within the classification of information one or two.
Whether a trial court held it is proved?
Yes, trial court tells.
Because
What the trial court says.
because there is death
Because
note.
of the death. Lord, may kindly have a look at the death note before we proceed further. Exhibit P11.
It runs into several pages.
No, those are all different writings at different points of time. That is why, my lord, those recovery of those other documents is doubtful. Lord, 19 in 2010, so there's only one sheet. ರಾಜೇಶ್ ನೀಡುತ್ತಿರುವ ಮಾನಸಿಕ ಮತ್ತು ದೈಹಿಕ ಹಿಂಸೆಯನ್ನು ತಾಳಲಾರದೆ ನಾನು ಸಾಯಲು ನಿರ್ಧರಿಸಿದೆ. ಅವರು ಹರ್ಷ ಎಂಬ ಹುಡುಗಿಯನ್ನು ಪ್ರೀತಿಸುತ್ತಿದ್ದರು. ಅವರ ಅಪ್ಪ ಅಮ್ಮನ ಫೋರ್ಸ್ಗೆ ನನ್ನನ್ನು ಮದುವೆ ಆಗಿದ್ದರು. ಅವರಿಗೆ ನನ್ನ ಜೊತೆ ಸಂಸಾರ ಮಾಡಲು ಇಷ್ಟವಿರಲಿಲ್ಲ. ತನ್ನ ಅಪ್ಪ ಅಮ್ಮನ ಹತ್ತಿರ ನನ್ನನ್ನು ಪ್ರೀತಿಯಿಂದ ನೋಡಿಕೊಳ್ಳುವ ನಾಟಕ ಮಾಡಿದರು. ಆದರೆ ಬೆಡ್ರೂಮ್ ನಲ್ಲಿ ದಿನ ಹರ್ಷ ಜೊತೆ ಫೋನ್ ನಲ್ಲಿ ಮಾತನಾಡುತ್ತಿದ್ದರು. ಇದನ್ನು ವಿರೋಧಿಸಲು ಹೋದರೆ ನನ್ನನ್ನು ಹಿಡಿದು ಒಡೆಯುತ್ತಿದ್ದರು. ಕೈ ನುಳಿಯನ್ನುತ್ತಿದ್ದರು ಹಾಗೂ ಜುಟ್ಟು ಹಿಡಿದು ಎಳೆಯುತ್ತಿದ್ದರು. 9 ತಿಂಗಳಿನಿಂದ ಇದೇ ರಾಮಾಯಣ. ಇದನ್ನು ಸಹಿಸಲು ಆಗದೆ ನಾನು ಸೂಸೈಡ್ ಮಾಡಿಕೊಳ್ಳುವ ನಿರ್ಧಾರ ತೆಗೆದುಕೊಂಡು ಮನೆಯಲ್ಲಿ ಯಾರೂ ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಮಾತಿನಲ್ಲಿ
ಕೊಲ್ಲುತ್ತಿದ್ದರು.
ಇನ್ನ ಈ ಜನ್ಮದಲ್ಲಿ ನನ್ನ ಹೆಂಡತಿ ಎಂದು ಒಪ್ಪುವುದಿಲ್ಲ. ನಿನ್ನನ್ನು ಎಲ್ಲಿಯೂ ಒಬ್ಬಳೆ ಎಂದು ಕರೆದುಕೊಂಡು ಹೋಗುವುದಿಲ್ಲ. ನಿನ್ನ ಮನೆಯಲ್ಲೇ ಬಿದ್ದಿರಬೇಕು. ಇದರ ಜೊತೆ ತುಂಬಾ ಅನಿವಾಗುವ ಮಾತನ್ನು ಆಡುತ್ತಾ ನನ್ನನ್ನು ಮಾನಸಿಕವಾಗಿ ಚಿತ್ರಹಿಂಸೆ ನೀಡುತ್ತಿದೆ. ಇದಕ್ಕೆ ಸಹಿಸುವ ನನ್ನ ಇಂದು ನಾನು ಇಂದು ಸೂಸೈಡ್ ಮಾಡಿಕೊಳ್ಳುತ್ತೇನೆ. ಅಪ್ಪ ಅಮ್ಮ ದಯವಿಟ್ಟು ಕ್ಷಮಿಸಿ. ನಿಮಗೆ ನನ್ನ ತಪ್ಪು ಮಗಳಲ್ಲ. ನಾನು ಸತ್ತರು ನೀವು ಯೋಚಿಸಿದೆ. ತನಿಷಾ ಮತ್ತು ಅಪ್ಪನ ಜೊತೆಯಲ್ಲಿ ತನಿಷಾ is one of the sisters. But this is all. There was a death note on 1980. Lord, she speaks about I having an affair prior to the marriage. Please. Now, my lord, what would be important is that PW 12 is a witness to this exhibit P13 and PW 9 is a witness to exhibit P14 for the other writings. For this exhibit P14, for the other death notes 11A, B, and the other writings, for the first informant takes it to the police station. Why it would be important is, my lord, the bureau was opened according to exhibit P30. Along with this death note, there are other writings that were found,
Yes.
which has shown as inserted, my lord, which I showed as 9 and 10. That was found from the cupboard as per exhibit P30. Lord, can you have a look at exhibit P30? Nine, cupboard ನಲ್ಲಿ ಶ್ರೀಮತಿ ಶ್ರುತಿ ಬರೆದಿದ್ದ ಒಂದು ಡೈರಿ. 10, ಡೆತ್ ಬಗ್ಗೆ ಬರೆದಿರುವ ಪತ್ರಗಳು 10. At 9 and 10. Page 3. So the cupboard was open and they found a diary and certain death, about death, some letters as per exhibit P30. Now, my lord, kindly have a look at exhibit P14.
ಡೆತ್ ಬಗ್ಗೆ ಬರೆದಿರುವ ಪತ್ರಗಳು.
Death ಬಗ್ಗೆ ಬರೆದಿರುವ ಪತ್ರಗಳು. As per 13. Lord, in 14, Lord, this father.
No, there is reference serial number 8, 9 and 10.
Please, Lord.
8 is rule Haleಯಲ್ಲಿ, that is dated 19/8/2010.
That is the death note.
Yes.
Exhibit P11.
Yes.
Lord, along with this exhibit P11, one notebook as well as certain letters pertaining to a death. That is 9 and 10. No, my lord, can you tell exhibit P14? Lord, this is the Mahazar dated 21/10/2001 between 10 a.m. and 11 a.m.
Yes.
Lord, here, Lord, the father of the deceased goes to the police station. Says that I have taken the clothes and other belongings of my daughter. And within those belongings, I found certain letters. And he produces those as per this mother.
ಎಷ್ಟು ಪೇಜ್ ಏನು ಹೇಳಿದಾರ?
Please, 8 ಹಾಳೆ ರೋಲ್ಡ್ ಹಾಳೆಯಲ್ಲಿ 8 ಪುಟಗಳ ಬರೆದಿರುತ್ತದೆ. ಇವು ಲಾಂಗ್ ಹಾಳೆ ಆಗಿದ್ದು 1 ರಿಂದ 8 ಎಂದು ಪುಟದ ಸಂಖ್ಯೆ ಬರೆದಿದೆ. ತನಗೆ ತೊಂದರೆ ಆಗುತ್ತದೆ ಬಗ್ಗೆ ಬರೆದಿರುತ್ತಾರೆ. And it also speaks about the dates. ಆಮೇಲೆ 2 ಕಟ್ ಮಾಡಿರುವ 2 ಚಿಕ್ಕ ರೋಲ್ಡ್ ಹಾಳೆಗಳು ತನಗೆ ತೊಂದರೆಯಾಗಿದ್ದ ಬಗ್ಗೆ ಇಂಗ್ಲಿಷ್ ಭಾಷೆಯಲ್ಲಿ ಬರೆದಿದ್ದು 2 ಕಡೆ ಸಹಿಗಳನ್ನು ಮಾಡಲಾಗಿರುತ್ತದೆ. ಒಟ್ಟು 4 ಪುಟಗಳಿಂದ 16/8/2010. So now these are certain documents which are recovered as per exhibit 14, produced in the police station by the father.
Yes.
Lord, this is in the presence of CW16 and PW9.
But these the handwritings found in these letters were also subjected to
For FSL. And the FSL officer says that all these writings are by the same person. Lord, I am not on that. Lord, recovery of exhibit
Yes.
11.
Yes.
Lord, both these mother witnesses say that it was in their presence. PW 9,
One minute.
please.
As per exhibit P14,
Please.
8 ಪುಟಗಳು ಸೀರಿಯಲ್ ನಂಬರ್ 1 to 8 ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು.
ಎಲ್ಲಿದೆ? That is subsequent one. ಇಲ್ಲಿ ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ. No, but this death note dated 19/8/2010. This is one sheet.
That is as per exhibit P13.
Thereafter there are 3 more sheets.
3 more sheets.
3 ಅಲ್ಲ 4 more sheets.
Please.
ಅದು that is apart from 8 sheets.
Please,
subsequently produced.
Because under exhibit P13, there were other sheets also found along with this death note dated 19.
ಇಲ್ಲ, ಒಂದು ಡೈರಿ 8 ಪುಟಗಳ ರೈಟಿಂಗ್.
ಇಲ್ಲ, this is your worship is looking at exhibit P14. Your Honor, kindly have a look at exhibit P13.
13 ಅದೇ.
13 ಅಲ್ಲಿ 9. Keyboard ನಲ್ಲಿ ಶ್ರೀಮತಿ ಶ್ರುತಿ ಬರೆದಿರೋ ಒಂದು ಡೈರಿ.
Yes.
And 10 death ಬಗ್ಗೆ ಬರೆದಿರುವ ಪತ್ರಗಳು.
Yes.
So my lord, there are other how many ಪತ್ರಗಳು they don't say.
ಡೈರಿ ಎಲ್ಲಿದೆ? ಡೈರಿ.
That is again
Whether it is marked?
It is not marked.
Not marked.
Lord, exhibit P21, PF 260 of 10. So that is pertaining to the admitted record. It is not marked. It is not marked.
ಪತ್ರಗಳು ಅಂತಂದ್ರೆ there is 4 pages there. That is referred to in exhibit P13 as ಪತ್ರಗಳು.
But then exhibit P14 also speaks about the letters.
Yes sir, there are several other. ಇದು 8 ಪುಟ ಇದೆ. 8 ಪುಟ ಬಿಟ್ಟು there are 4 more pages and one last death note dated 19/8/2010. ಇದು ಒಂದು page. These 4 pages. These 2 were recovered under exhibit P13 and later 8 pages. These were produced by the father.
Please, on 21.
Yes.
In the presence of PW9.
Seized under exhibit P14.
Please.
There cannot be any confusion regarding that.
No, the confusion is both these witnesses to this matter. Lord, PW9 and PW12 Lord claim that this exhibit P11 death note was recovered in their presence. Both identify exhibit P11. Lord, both are friends, they are relatives. Lord, there are no independent witnesses examined or referred to. All these witnesses, Lord, to all these matters are taken by the first informant. Lord, may kindly have a look at the evidence of PW12 and PW9.
See, one this writing exhibit P13 ನಲ್ಲಿ 4 pages ತಗೊಂಡಿದ್ದು. That is dated 17/12/2009. Within 1.5 months of our marriage.
And she says 16 to why it is doubtful. It's not in that document. She says that 16/12 was the last happiest day in her life.
Previous day.
So previous day.
Yes.
But the reading of it would show that since then I have been subjected to.
Yes.
So it cannot be the next day alone.
Next day. No?
Andres, that was the last day of happiness in my life.
Yes.
After that there has been no happiness.
Yes.
So within one day whether she can see that there is no. So if cannot be construed. No, it shows that it is a created document. It's what I would like to submit.
What was running in our mind, we cannot presume, sir.
Lord, that would again, Lord, I would come in the course of the argument. Lord, she had a tendency to commit suicide.
Why you say so?
Lord, it has come in the of the file.
Yes, it is also written in this
Please.
27/7/2010 ಅಂದು suicide ಮಾಡಬೇಕೆಂದು 30 ಟ್ಯಾಬ್ಲೆಟ್ಸ್ ತೆಗೆದುಕೊಂಡಿದ್ದೆ.
There is absolutely nothing to show that she has done it. But it is an admission that she has done it. So she had suicidal tendency.
Because it is only because of you.
Lord, I come to that. I come to that. Lord, her friend who is examining. Lord, she says that she was not in the habit of writing a diary earlier.
But you cannot dispute the handwriting expert's opinion.
No, why I am trying to? I'm not disputing Lord the opinion. I'm only stating Lord the defense case. But Lord, the PW11. Now it has either been recovered under Exhibit 15 or under Exhibit 14.
No, there are few pages. There are few pages of writing apart from death note, which runs into only single page. Recovered under Exhibit P13 and 14.
But Exhibit 11 is the death note.
Yes.
11A and 11B are the other writings which your lordship is referring to.
11 is the one single page, death note.
So, Lord, Exhibit 11, I am restraining my argument to Exhibit 11. Lord, was recovered under which document? Lord, as per the prosecution, it is Exhibit 13.
13.
Please,
Yes.
but Lord, both these witnesses, PW9 and PW12, say that this Exhibit 11 was recovered in that reference.
That is the lapse on the part of the prosecution. They do not understand, they do not read, they do not own any responsibility.
So my duty is only to put that doubt in the mind of the court.
Now let us ignore all other things.
No, Lord, because
Exhibit P11.
Recovery has to be proved.
Why recover?
Recovery is
No, you can dispute subsequent product recovery. Exhibit P13.
Please, now Exhibit P13. Lord, it shows said to have been prepared on the date of the incident, 1908.
Yes.
Lord, 1908 it is said to have been prepared. Lord, between 7:15 a.m. and 7:15 p.m. and 8:15 p.m. Lord, on 1908, Lord, the FIR has been submitted to the learned magistrate. Lord, the learned magistrate receives the FIR on 1908 at 10 p.m.
Receiving of the FIR is not a
No. Why I would say?
registration of the FIR. Immediately the investigation will begin.
Certainly.
Yes.
No, why I am trying to say, if this document was actually prepared on 19/8/2010 between 7:15 a.m. and 8:15 p.m., it should have been submitted to the magistrate when the FIR was submitted. It is submitted to the learned magistrate.
One FIR was registered at what time?
Registered at 6:35 p.m. After the registration of the FIR, the spot measure is done. Exhibit P13 at between 7:15 p.m. and 8:15 p.m.
Between
7:15 p.m. and 8:15 p.m.
Yes.
And Lord, subjected to PS number 201. Again dated 1980. Both these documents, the PS as well as the Exhibit P13, under section
when
it has to be done immediately
when the FIR reached the learned magistrate
at 10 p.m. on 19/8/2010. But this document, if it was actually ready on that day,
Is there any cross-examination to the investigating officer?
I think.
If there is any cross-examination, you can highlight.
Yes, it is.
But otherwise, you cannot presume that the FIR was,
Yes, it is.
see, general practice, generally we presume FIR is registered at 6:35 and immediately it is dispatched. Thereafter, the spot master recovery and everything has followed. Unless there is a cross-examination and something is elicited from the investigating.
It has been.
Show it.
If my memory, I will just come to that.
Yes.
But now, before that, before I come to the evidence, but I wanted to go through this document. But now, Exhibit P13, 19/8/2010, produced before the magistrate on 21/10.
2110.
Please, 21/10, 2010.
But even then, once it is the prosecution is successful in proving that the writings is that of the deceased.
No, my lord, I am on the ground. Lord, the thing comes subsequently. First, Lord, the recovery. Lord, whether there has been any manipulation.
Manipulation is there must be some materials.
Lord, now the admitted, see, the opinion of the FSL is on the basis of the admitted writing.
No, admitted with the questioned writings.
Please, but now the admitted writings are again given
No.
by the father.
Yes.
Lord, these recovery of these notes, Lord, also claim, Lord, it shows that it is a subsequent reference.
What are the admitted writings?
Lord, a notebook, Exhibit P20. Lord, the bank opening form.
Do you dispute that? Do you dispute that?
Lord, there is a general dispute with regard to it.
Allah, what is the basis for that? Dispute generally is, of course, ella sullu. That is there.
I would not speak, sir, but that has not been done by the trial.
Then
It is not. But now, my lord, the Exhibit P13 and Exhibit P14, because, my lord, the death note can be looked into only if the recovery is true. But death note by itself cannot be a substantial piece of evidence.
but why you are disputing its recovery?
Lord,
Only on the basis of the fact that it has reached the learned magistrate
I
belatedly.
am disputing it because the entire investigation, Lord, looks to be with the single dimensional light. But all the witnesses to the mothers are the friends. This father is to take the witnesses along with him. There are no independent witnesses. All the witnesses.
Sir, how can you expect an independent witness in such cases?
But for mothers, is what the known person
That
from
is
the locality.
that is the ideal situation, sir.
Lord, even otherwise,
No
Lord, the
person
immediate-
will go. No
Lord, the
person
immediate
will go.
neighbors, the immediate neighbors of the locality.
Even if the police will come and invite you to be the master witness, you say no, I have other better job.
Then that has to be according to the question.
That is the situation, sir. Ille
There
ಆಯ್ತಲ್ಲ.
has to be such.
Few years back there was a stab, the instance of
There was no.
none of the advocates were ready. That is the hard reality.
There should be mentioned in the document.
Even the advocates were not ready, and that too within the high court premises.
It was
Hmm.
in the presence of me.
Yes, that is the situation.
It is not my, I'm only here to create a doubt.
Of course, see, I'm telling you. See, the death note is dated 19/8/2010.
On the date of it.
On the date of incident, there is a very clear, and this handwriting, it is stated, is that of the deceased. And apart from that, there is 4 pages note said to have been written by the deceased, and the handwriting is proved to be of her. And these 4 pages were written on 17/12/2009, within 1.5 months.
Please, but my lord, in that document appears to be doubtful. For the reason, the mental state of the girl also has to be looked into. My lord, she says one day before, she was very happy.
Yes.
And the way it is written, as though it is from several months.
Again, ಎಲ್ಲಿದೆ ಅದು?
ರೀಡಿಂಗ್ ಆಫ್ ಇಟ್ ಅಲ್ಲಿ ತನಕ ಅಂದ್ರೆ ಒಂದ್ ದಿನದಲ್ಲಿ ಪ್ರಪಂಚ ನೋಡ್ಬಿಟ್ರ
ಹೇಳ್ತಾರೆ ಸರ್, ಅಷ್ಟು ಕಷ್ಟದಲ್ಲಿರೋತಿಗೆ ಹೇಳ್ತಾರೆ ಅವರು. ನಿನ್ನೆವರೆಗೆ ಚೆನ್ನಾಗಿದ್ದೆ, ಇವತ್ತು ನನ್ನ ಜೀವನ ಹಾಳಾಯ್ತು ಅಂತಂದ್ರೆ ಡೂ ಯು ಮೀನ್ ಟು ಸೇ ಒಂದು ವರ್ಷ ಆದ್ಮೇಲೆ ಬರಿಬೇಕು ಅಂತ? ನೋ ಸರ್, ಎನಿ ಗರ್ಲ್ ಫಾರ್ ದಟ್ ಮ್ಯಾಟರ್. Every child will be pampered, sir. Every child will be pampered. ನಮ್ಮ ಮಕ್ಕಳಾದಾಗ ಪ್ಯಾಂಪರ್ಡೆ, ಅದರ್ಸ್ ಆದಾಗ ನಡೀತದೆ. ಲಿಟಲ್ ಕರೆಕ್ಟು. ಅದಕ್ಕೊಂದು ಸ್ವಲ್ಪ ಸ್ಪೇಸ್ ಕೊಡ್ಬೇಕಲ್ವಾ ನೀವು? 1.5 months ಅಲ್ಲೇ ಅವಳು, ಇಫ್ ಶಿ ರೈಟ್ಸ್ ದಿಸ್ ಲೆಟರ್, 4 pages letter explaining what should be her condition. I can understand after 4 years, 5 years. I can understand. 1.5 months.
No. The very same letter, what she says is that I love Ramesh. I cannot live without him. He is not going to accept me.
Yes.
So I am committing.
Correct.
So it is not that she was not loving him. In spite of
no, she was loving him, but what about him? What about the appellant? He is talking to somebody else. No girl will tolerate that. Definitely that would be an abatement.
But then, for that to be established, one year cited this girl as a witness. Why is it that? Sir,
established means within short span of 7, how many months? 9 months, she committed suicide. And within 1.5 months, she has written this letter, which is proved to be in her own handwriting. Can it be rejected, ignored altogether?
I would say no, because it might come within the classification or explanation 1 of section 498A. For her mindset,
correct,
that was sufficient for driving her to commit suicide.
Yes.
Because she had earlier suicidal tendency. What is it that the parents try to do? Because the entire, all these notes,
suicidal tendency not before marriage, only after marriage.
But
that is due to your conduct.
That's right. But it is regarding to what? It is only regarding to an affair which I was having with this girl, and I am not taking care.
Do you say that it is not sufficient?
No. What I am trying to say is, if this was within the knowledge of the parent, why was it not stated? Why was a detour taken that it was in connection to dowry? Because this girl's mention is not there in any of the documents. This is the reason she was sad. This is the reason which was going behind the corner of her mind.
Maybe the girl has not expressed this to the parents. The parents were under the impression that it was due to the demand for dowry.
The evidence they say that she used to come and tell. Let's come in there.
So you mean to say the contents of death note is not spoken to by any of the witnesses?
None of the witnesses. None of the witnesses during the course of investigation. First time.
No. What is the evidence? Whether they have spoken to about that?
The evidence they have spoken, that they knew. Even otherwise, on 306, equipment has got to be under 109. So I had to do an act which drive her to commit suicide. It has to be a possibility. It has to be a direct cause.
Yes.
It cannot be a proximate cause.
Yes.
But here I have stated that I am not going to accept you. You go to your parents.
Not only that, sir. Not only that. You physically assaulted her, dragged her by holding her hair.
With regard to
and moreover, you are talking to somebody else over phone for hours together.
But whether that is the only step available to her.
ಅದು ಇವಾಗ ನಾವು ಚರ್ಚೆ ಮಾಡುವಂತದ್ದಲ್ಲ. A newly married girl with so many expectations, she will come to the house. What will run in her mind? We do not know. Otherwise, it will be very difficult to hang oneself.
It takes a lot of
courage. Yes. It is not so easy.
So the PM report does not speak of any other injury.
No, there will not be any other injury. Yes, there will not be any other injury except the strangulation mark.
Yes, that's the only anti-mortem injury
Correct.
referred to.
Yes, that rules out any physical assault. ಜುಟ್ಟು ಹಿಡಿದು ಎಳೆಯುತ್ತಿದ್ದರು ಅಷ್ಟೇ, ಅದಕ್ಕೇನು ಇಂಜುರೀಸ್ ಆಗೋದಿಲ್ಲ.
But as it is a lesser offense, 306, the conviction came. But paras 44 onwards.
See this exhibit P11. One is dated 19/8/2010. The other is 17/12/2009. Within 1.5 months, what will happen? What? If that was not the reason, there cannot be any other reason for a newly wedded married girl.
Constantly, the reason is the same.
Yes, it has not changed.
So
there is consistency. ಕೊಲ್ಲುವೆ ಎಂದು ಭಯಪಡಿಸುತ್ತಿದ್ದ.
As per the charges that are framed, the charge with regard to 498 is against the accused number 1. Is this fair that he had? But for the offense under section 304B, Red Bill section 302, Red Bill section 54, the charge is that soon before her death, in connection with demand of dowry, she committed suicide.
ಅದಾಯ್ತಲ್ಲ, ಅದೀಗ you are acquitted for that.
No, but then there is no charge of 306 or 304B that she committed suicide because of this affair. But under 498A, that is a charge against me. And this is the affair that subjected her to cruelty, insofar as A1 is concerned.
304B ಗಿಂತ lesser offense ಅಲ್ಲ ಇದು 306.
Yes, but 304B not that I drove her to commit suicide because of this affair or because of the assault that I was subjected to her because of this affair. It is in connection with dowry. The charge number 4.
Yes.
That the deceased being your wife and daughter, respectively unable to bear your cruelty and harassment, subject by all of you soon before her death, in connection with demand of dowry, committed suicide on 19/8/2010.
So you mean to say at the most only 498A,
498A,
not 306.
And Lord, I was throughout the trial, Lord, I was in custody.
How many years? How many days?
Lord, till I was enlarged on bail. Lord, from 28, Lord, the judgment itself shows Lord, 28/2010 till 23/1/2014.
23/1/2014.
2014.
Thereafter he was released.
On 23, yes. Subsequently, after the order of this on was released. More than 3 years, the maximum.
3 years, 5 months.
5 months.
Yes. Why such inconsistency in your evidence in the case made out? Clear deviation from the death note. According to you, the death note was recovered on the same day. Hmm. But you stick on to your version that there was demand for dowry, cruelty related to the demand for dowry. Hmm. Death note was available with the investigating officer. Why the investigation has not been done in that line? Hmm. Very surprising. The investigating officer was not bothered. The prosecutors were, as usual, they were not bothered. And even the trial court. Very, very shabby investigation, shabby trial conducted. And the witnesses speak as if the letters were recovered under Exhibit P13. Even the prosecutor may not be knowing which document was recovered under which mahazar. Generally, so they will not be knowing because there is no accountability. Hmm. Hmm. Then why this charge number 4, 304B, read with 302, in connection with demand for dowry? Where are the materials? Hmm? Charge is one thing, the materials that are placed is one another thing. The evidence given by the witnesses altogether different. Then how can you say that you proved the guilt beyond reasonable doubt? Hmm. You see, the trial court comes to the conclusion, and rightly so, 304B and 30 read with 302 is not proved. Then where is the material for 302, 6? 306, you are basing your say on death note. But recovery is not proved, according to him. The evidence given by the Mahazar witnesses are entirely different, as if all the writings were recovered under Exhibit P13 on the date of incident. But in fact, many 8 pages were recovered, said to have been recovered by the father while collecting her belongings. Yeah, subsequent date. Who has to speak about that? Only by looking at the Mahazar we should presume, is it? Hmm. ಅಷ್ಟೇ ಇವಾಗ ಚಾರ್ಜ್ ನಂಬರ್ 3 ಅಷ್ಟೇ. 1 and 2 ನಾಟ್ ಪ್ರೂವ್ಡ್ ಮೊದಲೇ ಆಗಿದೆ. ಇವಾಗ 4 ನಾಟ್ ಪ್ರೂವ್ಡ್, ಕೆನಾಟ್ ಬಿ. See, may not be 304B, 3 read with 302, maybe 3, it may be 306, maybe. But what is the reason? What is the basis? Subjected to harassment soon before the death in connection with the demand for dowry. That is the specific case made out by the prosecution. Hmm. That will not. Hmm. Abatement is to be proved. According to it is demand for dowry. That is not the content. That is not the case. Maybe what prevented the prosecutor to request the alter the charge? He was knowing at least. The trial court was knowing. Why there is no application of mind? It is not only procedural, it goes to root of the matter. How can you expect that the accused will defend such type of charges? The only focus will be demand for dowry and harassment. Maybe injustice it is only because of the prosecution. Yes. Ah. When there is no such case made out, how can you expect that the accused will be convicted for such offense? First of all, 306 is not made out. Let us assume 304B is there, 302 is there, it's okay. But what is the reason? A specific reason demand for dowry. The two after conclusion of the investigation, after recovery of the this one death note, after receiving the handwriting expert opinion, and still you maintain there was demand for dowry, and the harassment is related to that. Hmm. So should the court close its eyes, saying that no, in spite of all this, the deceased died. There is a death note, so I will relate to that. That cannot be. That cannot be. Correct. Correct. Who should have that seriousness? Who should have that seriousness? The investigating officer should have that seriousness. The prosecutor should have seriousness. The court should have seriousness. None of them. And ignoring all those things, some or the other way convict the accused. That cannot be. It is apparently it is the blunder committed. Yes, nothing. It was a very easy case rather for the prosecution to prove. Even then, if this is the situation. So, question of proving charge number 4 does not arise. Only 498. There is, of course, there is the support of death note recovered under Exhibit P13. Even if we were to ignore the other recovery, we can base it for the recovery under Exhibit P13 on the date of incident. Madam, at least while filing the charge sheet, the investigating officer must be certain what has triggered, what is the reason for the abatement. It should be spelled out. At least while framing the charge, the trial court must say it. This is the abatement. It is the right of the accused to know that. Otherwise, you can say, Satyadare, so you are responsible. That cannot be. 302 or likely. Something more is to be proved. 304B ಇನ್ವೋಕ್ ಮಾಡಿದಿರಿ ರೆಡ್ ವಿತ್ 302 ಎಲ್ಲಿದೆ ಮೆಟೀರಿಯಲ್ ಟೋಟಲ್ ನಾನ್ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ignoring the materials on record. So 4 ಇಲ್ಲ ಅಷ್ಟೇ 498 ಎಷ್ಟು ಮಿನಿಮಮ್ ಎಷ್ಟು ಸೆಂಟೆನ್ಸ್ 498 ಗೆ ಎಷ್ಟು
maximum is 3 years.
3 years shall also be liable to fine. Accused number 1 in SC 335 of 2011 is impugning the judgment of conviction and order of sentence dated 5th December 2013, the SC 335 of 2011 on the file of so and so, convicting him for the offence punishable under section 498A and 306 of IPC, and sentencing him to so and so, while acquitting him for the offence punishable under section 304B, 302 of IPC, and under section 3 and 4 of DPA, and also acquitting the accused number 2 and 3 for all the charges leveled against them. Case of the prosecution in brief is that appellant accused number 1 married the deceased on 9/11/2009. The accused 1 to 3 with the common intention to demand the gold ornaments and cash of rupees 25,000 towards dowry, subjected the deceased to cruelty. It is also the contention of the prosecution that accused number 1 had received two gold bangles, three gold rings, a gold long chain, two pairs of gold ear studs, gold Mangalya chain, gold nose stud, necklace, etc. as dowry, and thereby committed the offence punishable under section 3 and 4 of BP Act. It is also its contention that accused number 1 was demanding rupees 4 lakh per purchase of car, punishable under, and thereby committed the offence punishable under section 4 of DPA. ಇದನ್ನು ಕೆಳಗೆ ಹಾಕಿ ಅಲ್ಲಿ ಮೇಲ್ ಬೇಡ ಇಲ್ಲೇ ಹಾಕಿ thereby committed the offence punishable under section 3 and 4 of DPA. It is the further contention of the prosecution that the deceased used to talk with his colleague CW10 and subjected the deceased to cruelty to commit the offence under section 498A read with 34 of IPC, and further she was subjected to cruelty and harassment soon before her death in connection with demand for dowry, which resulted in her death on 19/8/2010 by hanging in the house of 19/8/2010 at 3 p.m. in the house of accused number 1, thereby committing the offence under section 304B read with section 302 of IPC. The accused has appeared before the trial court, pleaded not guilty. But charge sheet came to be filed for the offence punishable under section 304B, 498A of IPC, and under section 3 and 4 of DPA. The learned magistrate committed the matter to the trial sessions court. The accused have appeared before the trial court, pleaded not guilty. They claim to be tried. Prosecution examined PWs 1 to 22, dot marked exhibit P 1 to 53, and identified MOs 1 to 17 in support of its contention. The accused have denied all the incriminating materials available on record in their statement under 313 of CRPC, but have not chosen to leave any evidence in support of their defense. The trial court, after taking into consideration these materials on record, passed the impugned judgment, holding that the prosecution is successful in proving the guilt of accused number 1 of the offence punishable under section 498A and 306 of IPC, while acquitting him for the offence under 304B, read with 302 of IPC, and under section 3 and 4 of DPA, and also acquitting accused number 2 and 3 for all the charges leveled against them. Being aggrieved by the same, the appellant is before this court. Heard so and so. Here is the material. Point for consideration. My answer to the above point partly in the affirmative for the following reasons. It is the contention of the prosecution that the appellant accused number 1 had married the deceased on 9/11/2009. After marriage, she was residing in her matrimonial house with the appellant. She died in his house on 19/8/2010, that is within 9 months after the marriage. All these facts are not in dispute. The materials on record discloses that she died due to hanging in her house. The postmortem examination report, Exhibit P29, discloses that the death was due to asphyxia as a result of hanging. No other external injuries were found on her body. To prove the contention of the prosecution that she was assaulted or subjected to cruelty, physical cruelty, soon before her death. Next. PW1 is the inquest master witness to Exhibit P1. PW2 is the elder sister of the deceased, who said to have received the phone call from the deceased just before the incident. PW3, 4, 5, and 6 are the official witnesses who speak about the procedure adopted during investigation. PW7 and 8 are the mother and the father of the deceased. PW8 is being the father is the informant who lodged the first information as per Exhibit P12. As per Exhibit P12, filed immediately after the incident, the reason for the deceased to die was demand and acceptance of dowry by accused number 1 and demand for additional dowry. Exhibit P13 is the Mahasa, drawn on the same day of the incident, that is on 19/8/2010, immediately after registration of the FIR, according to which the death note as per Exhibit P11 were recovered from the house of, at the scene of occurrence, that is from the house of the appellant and the deceased. First sheet in Exhibit is the writing said to be in the handwriting of the deceased, written on 19/8/2010 itself, that is just before the incident. As per this death note, the accused number one was treating her with cruelty as he was in love with another girl by name Harsha. Accused had married the deceased due to the pressure by his parents. Therefore, the accused was talking to the said Harsha over phone on everyday basis from her bedroom, and he used to ill-treat her both physically and mentally, which has driven her to take the extreme step of committing suicide. Other four sheets of writings said to be of the deceased were also said to have been seized under Exhibit P13 on the date of incident itself, where she has referred to the conduct of the accused in ill-treating her immediately after the marriage, as these writings were dated 17/12/2009, that is within 1.5 months of her marriage. Strangely, in none of these writings marked as Exhibit P11, seized under Exhibit P13 on the date of the incident itself, there is reference to any demand and acceptance of dowry by the accused. In spite of that, the specific case made out by the prosecution is that the deceased was subjected to ill treatment as there was demand for dowry, and the same was not met by the deceased and her family members. Attention taken by the first informant and the contention of the prosecution as stated in the charge sheet, and further the charge framed by the trial court revolves around demand and acceptance of dowry and demand for additional dowry, and treating the deceased with cruelty in connection with the demand for dowry. Whereas the death note Exhibit P11 speaks something else, and the demand and acceptance of dowry by accused number one is conspicuously missing in the death notes, death and other notes recovered under Exhibit P13. Next part. Strangely, the trial court framed the charge numbers 1 and 2 with regard to the demand and acceptance of dowry and additional dowry, and for the offence under section 3 and 4 of DP Act. The trial court rightly held that these charges number 1 and 2 are not proved by the prosecution. Charge number 4 is with regard to subjecting the deceased to cruelty and ill treatment in connection with the demand for dowry, which led to her suicide on 19/8/2010, and thereby committing the offence under section 304B read with section 302 of IPC. When the deceased herself do not refer to any demand for dowry in her death note said to have been recovered from her house soon after the incident, I do not find any support to prove charge number 4 Charge number 4. Simply because the deceased died within 1.5 years of her marriage will not automatically lead to conviction of the accused under Section 306 of IPC when no such charge is framed and no such case is made out against him, and there is absolutely nothing on record to prove demand and acceptance of illegal acceptance of dowry and demand for additional dowry to be the cause for harassment for abatement of commission of suicide. Under such circumstances, I am of the opinion that conviction of the accused for the offence under Section 306 of IPC cannot be sustained. Next, charge number 3, framed by the trial court, relates to the harassment or cruelty meted by the appellant to the deceased by talking with the colleague of the accused by name Kumari Harsha, cited as CW10, and subjecting the deceased to cruelty and thereby committing the offence punishable under Section 498A, read with 34 of IPC. The death note Exhibit P11 recovered under Exhibit P13 under the very date of incident throws much light about proof of discharge. Exhibit P11 death note dated 19/8/2010, that was just before committing suicide. The deceased has referred to the very same Harsha, the colleague of the appellant hearing, and stated that the appellant was in love with her and he used to talk to her every day in the night over phone, and in that regard he used to ill-treat her both physically and mentally. The other 4-page note dated 17/12/2009 also refers to the ill-treatment meted by the appellant to the deceased. That is within 1.5 months of her marriage with the appellant. These writings were forwarded to the handwriting expert with the admitted handwritings of the deceased, and the report of the handwriting expert is as per Exhibit P49. The questioned handwriting found in Exhibit P11 was found to be of the person who has written the admitted handwritings. Thereby, the prosecution is successful in proving that the death note Exhibit P11 is in the handwriting of the deceased, where she has described in detail about the ill-treatment meted to her by the appellant soon before her death. Which will squarely attract Section 498A of IPC. Therefore, I am of the opinion that the appellant is liable for conviction only for the offence punishable under Section 498A of IPC and not for 306 of IPC. It is also pertinent to note that the state has next para. It is pertinent to note that the state has State, even though has preferred the criminal appeal number 296 of 2014, it is only against adequacy of sentence imposed on accused number 1 for the offence punishable under section 498A and 306 of IPC. The maximum punishment that could be imposed for the offence punishable under section 498A is 3 years imprisonment and with fine. The trial court has already sentenced the accused appellant
Two years RI,
hmm?
5,000
2 years,
2 years only. For 498.
2 years. Rigorous imprisonment for 2 years with fine of rupees 5,000 with default sentence.
Default sentence of 3 months.
Yes. But the state has not challenged acquittal of the appellant for the offences under section 3 and 4 of PP Act, nor under section 304B and with 302 of IPC. It has also not challenged the acquittal of accused number 2 and 3 for all the charges leveled against them. Under such circumstances, I am of the opinion that that can be confirmed. 498A sentence could be confirmed. Sentence and conviction and sentence could be confirmed. Under such circumstances, looking to the facts and circumstances of the case, I am of the opinion that the trial court was right in convicting the accused for the offence punishable under section 498A of IPC and sentencing him to undergo rigorous imprisonment for 2 months to pay a fine of rupees 5,000 with the default sentence. Hence, I am of the opinion that the impugned judgment of conviction and order of sentence convicting the accused for the offence punishable under section 306 of IPC is liable to be set aside. Accordingly, I answer the above point partly in the affirmative and proceed to pass the bill. Appeal is allowed in part. Impugned judgment of conviction and order of sentence passed against the appellant for the offence punishable under section 498A of IPC is confirmed. The impugned judgment of conviction and order of sentence convicting the appellant for the offence punishable under section 306 of IPC is set aside. Send back the trial court records along with so and so. That's correct. Criminal appeal number 25 of 2014 is allowed in part. Point 2 ಮಾಡಬೇಕು. So 25.14 partly in the affirmative. 296 of 14 negative. I do not find any reason to entertain the appeal 296 of 2014 preferred by the state. That is dismissed. Appeal 296 is dismissed. Criminal appeal 25 of 14 is allowed in part. ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ಒಂದು ಕಡೆ ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್. ಒಂದು ಕಡೆ learned counsel for the appellant submits that the appellant was apprehended and detained in custody on on 28/2010 till 23/1/2014. Therefore, he has already undergone the sentence imposed by this court. The superintendent of prison may take note of the same to find out whether the accused has already served the sentence. If he has already served, he may be released forthwith. Yes.
Serial number 18, M. Sharat Chandra, ABK Swami.
Naturally, 15 years I think ಎಲ್ಲಿ ಬರುತ್ತೆ?
ಮಹಾರಾಷ್ಟ್ರ ನಮ್ದು ಫೈಲ್
the file.
ಎಸ್ ಮಹಾರಾಷ್ಟ್ರ
Both of you.
ಫೈಲ್ ಮಾಡಿದೀವಿ.
ನಮ್ದು ಇದನ್ನು ತೆಗೆದಾಕ್ಬಿಡ್ತೀನಿ, ಹೋಗ್ಬಿಡಿ. ನಾವು ಯಾಕೆ ಇಟ್ಕೋಬೇಕು? ತಗೊಳ್ಳಿ. Then counsel for the appellant and respondent number 1 pay for time on the ground that they have lost the file. The appeal is of the year 2010, which is one of the oldest matter that is pending before the oldest matters that are pending before this court. I do not find any reason to adjourn the matter. However, to afford one more opportunity list on. Afford final opportunity list on. No further adjournment on any ground. You go through the original records and get prepared. Next.
Serial number 19, H. Jayan, P. Prasanna Kumar. Jayan.
Good.
Serial number 19,
19 ಯಾರಿದ್ದಾರೆ? Order sheet. Counsel for the appellant is absent or representation. Order sheet dated 18/6/2025 reads as under. In spite of that, there is no representation. When counsel for respondent is present. Even though I do not find any reason to adjourn the matter, to afford one more opportunity list on. Finally, next.
serial number 20, Nagendra B. Nagendra.
Counsel for the appellant is absent, no representation. Order sheet dated 11/6/2025 reads as under. In spite of that, there is no representation. Hence, so and so is appointed as amicus curiae to assist the court in disposal of the matter on merits, since the appellant is in custody. Office is directed to communicate this order to the learned amicus curiae by supplying the copies of so and so. Learned amicus curiae and the learned SPP are directed to address their arguments on the next date of hearing without fail. ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು, ರೆಡಿ ಆಗಿರ್ಬೇಕು ಅಂತ ಅವರಿಗೆ ಹೇಳಬೇಕು. Yes.
Serial number 21, R. Vidyasagar, P. Prasanna Kumar.
Counsel for the appellant is absent, no representation. Order sheet dated 16/6/2025 reads as under. In spite of that, there is no representation. Hence, so and so is appointed as amicus curiae to assist the court in disposal of the matter on merits. Office is directed to communicate this order to the learned amicus curiae and supply the copy of so and so. Learned amicus curiae and the learned counsel for the respondent are directed to address their arguments on the next date of hearing without fail. Umesh, yes. Yes, amicus curiae is appointed. Next.
Serial number 22 HP Leeladhar.
ಅದು ಎಲ್ಲದರಲ್ಲೂ fees is fixed at 10,000 ಮಾಡಿ. Fees of the amicus curiae is fixed at 10,000. Next.
Serial number 22 HP Leeladhar.
Counsel for the appellant is absent no representation. Order sheet dated 18/6/2025 reads as under. In spite of that, there is no representation. So and so appointed as aforesaid. Both are directed or the same. Yes. Next. Final int ಇತ್ತಲ್ಲ ಅದು ಆಯ್ತು ಬಿಡಿ. Reads as under. In spite of that, there is no representation. I do not find any reason to adjourn the matter. However, to afford one more opportunity list on. Next.
Serial number 23 Shivarajanalli connected matter Girish P. Baldare.
I appear for the accused number 4 and 5, their appeal minutes against conviction.
My lord, I am appearing for the accused number 1, 3 and 7, my lord. My lord, the retirement memo has been filed.
Who filed the retirement memo?
Girish B. Baldare.
When?
On 3rd July of
ಇದೆಯಾ ನೋಡಿ ಅದು ತಗೊಳ್ಳಿ. ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 1133 of 2013, 1173 of 2013. Then counsel for the appellant submits that he has filed memo seeking permission to retire from on behalf of the appellant. The appeal is of the year 2013. In view of the memo seeking permission to retire, then counsel for the appellant is permitted to retire. So and so he is appointed as amicus curiae to represent the appellant and to address the arguments on merits. Office is directed. ಮಾಡಿ ಅವರು ರೆಡಿ ಇದ್ರೆ ಮಾಡಿ, ಅವ್ರು ಇಲ್ಲ ಅಂದ್ರೆ ಬಿಟ್ಟು ಅಷ್ಟೇ. The ಎರಡರಲ್ಲಿ ಮಾತ್ರ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 1133 of 2013, 1173 of 2013. This is directed to communicate this order. This time, yes.
One submission in this matter.
Yes.
I appear for accused number 4 and 5 and in appeal number 1155 of 13 minutes.
Yes.
Fifth accused, who is second appellant in this case, I have heard that he is no more.
Yes. ತಗೊಳ್ಳಿ. Appellant number. Learned counsel for the appellant ಇದು 1155 ನಲ್ಲಿ. Learned counsel for the appellant submits that. Appellant number.
Appellant number second appellant, fifth accused minutes.
Public accused number 5.
Money.
He is no more. Submission is placed on record. Appeal by appellant number 2 is dismissed as abated. Yes, amicus curiae is appointed. Next date of hearing, please address the argument.
Please, I'm ready.
Yes. Next.
Any date make any.
Date ಕೊಡ್ತಾರೆ.
Please.
Next.
Serial number 24, VB Kalpana, amicus curiae, is Balakrishna, government advocate.
ಯಾವಾಗ after appointment of amicus curiae. ಅದು ಮೊದಲೇ ಯಾಕೋ ತಗೊಂಡ್ಬರ್ಲಿಲ್ಲ. ಲಾಸ್ಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಏನಿದೆ ಕೊಡಿ. ಆಗಿದ್ದಲ್ಲ ಆಗಿ. Yes.
My lord, the offence is said to have occurred on 25/4/2010, my lord. My lord, this is under 376 and 420 of IPC, my lord. Its conviction is under 376 and 417.
What about 420?
420 illa son. The charge is under 420, whereas the conviction is under 417.
Yes.
My lord, the complaint is on 19/6/2010, my lord. For the offence that said to have occurred on 25/4/2010.
Date of offense?
Date of offence 25/4/2010.
Date of complaint?
19/6, my lord. 19/6/2010.
Who is the complainant?
Complainant is the victim herself. She is aged around 19 years. She alleges that on the pretext of marriage, he lured the victim, the accused lured the victim for sexual intercourse and thereby the offense, commission of offense. My lord, the complaint is at page number 4, my lord, exhibit P2.
Who are PW1? Who is PW1?
PW1 is one Nagaraj, my lord, Mahazar witness.
Which Master?
ಸ್ಥಳ ಪಂಚನಾಮ ಸ್ವಾಮಿ. ಆಕೆ ಮನೆ ಯಾವ್ದಿದೆಯಾ ಆ ಮನೆ.
Where the offense was
Mane.
committed?
Offense is said to have committed at Bagini Lodge, my lord. She alleges in her complaint that on 2012-2019, he took her to Bagini Hotel at Marathalli. Marathalli doesn't come under the jurisdiction of DG Halli Police, my lord.
Who is PW2?
PW2 is he is one of the witness who said to be, who says that this victim was staying in a house where he was collecting the rent. And ಅವನು ಆ ವಿಕ್ಟಿಮ್ಗೆ ಅನುಕೂಲ ಮಾಡಿಕೊಡ್ತಾನೆ ಕಂಪ್ಲೇಂಟ್ ಲಾಡ್ಜ್ ಮಾಡೋದಕ್ಕೆ ಮತ್ತೆ ಪೊಲೀಸ್ ಜೊತೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅಲ್ಲಿ.
PW3?
She is a victim, my lord.
PW4?
4 is a doctor, my lord, who gave a report.
Report is exhibit?
Report is at exhibit 3 and 4, my lord.
Examine the victim, is it?
Victim and as well as the accused. 5 is police constable, my lord, who have
Exhibit?
my lord.
Doctor report?
Doctor report is at exhibit P3 and 4.
3 is for of the victim.
Victim. 4 is accused.
Hmm.
Medical certificate of accused.
Yes, PW 5.
5 is a police officer, police constable, my lord, who apprehended the accused.
PW 6.
PW 6 is also police officer, police constable, my lord, who had took the victim and the accused to the police station.
PW 7.
No, 7 is also the same, my lord.
PW 8.
8 is the investigation officer.
So only PW 3 is the material. PW 3 and 4.
Yes, my lord. Nagraj, though he was a signatory to the Mahazar, he says that he doesn't know anything about the Mahazar. However, my lord, his statement also throws a light that where this victim was staying, whether the Mahazar conducted in that said house is where this victim was staying. Anta heli. Victim was not staying in that house. That is the
No Mahazar was drawn at the scene of occurrence.
no. No Mahazar was drawn, no witness is examined. Mean to say charge sheet witness illa. Bagini Lodge nor yaru charge sheet witness illa. Complaint which is at page number 5, my lord.
Exhibit.
Exhibit P2, my lord.
Yes.
Adರಲ್ಲಿ next line ಅಲ್ಲಿ third paragraph ಅಲ್ಲಿ. Page number 5 ಅಲ್ಲಿ. ಬಗಿನಿ ಲಾಡ್ಜ್ಗೆ ಹೋದ್ವಿ ನಾವು ಅಲ್ಲಿ ದಿನಾಂಕ 20/12/2009 23/12/2009 ಅಲ್ಲಿಯೇ ಇದ್ದು
From
2012-2009 ಅಲ್ಲಿಂದ 23/12/2009 ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್ ಅದು. ಅದಾದ್ಮೇಲೆ 17/4ರಿಂದ 17/4/2010 ಅಲ್ಲಿಂದ 18/4/2010 ಈ ಪೀರಿಯಡ್ ಅಂತ ಹೇಳಿ ಆಕೆ ಹೇಳೋದು. ಆದ್ರೆ FIR ಅಲ್ಲಿ ಅಕರೆನ್ಸ್ ತೋರ್ಸೋದು 24/10 ಅಂತ. Victim doesn't say anything about that.
24/10/2010. As per evidence of victim.
Evidence of victim also she doesn't say anything about 24/10, 25/4. Exhibit P3 is in contradiction with what the victim has said, my lord, at page number 11. This is the medical report, my lord.
Why you say exhibit P3 is against?
P3, my lord, exhibit P3. ಅದರಲ್ಲಿ third page, my lord. Opinion, ಅಂತಿಮ ಅಭಿಪ್ರಾಯ. ಅದರಲ್ಲಿ 2ನೇ ಪಾಯಿಂಟ್.
Yes.
ಪರೀಕ್ಷೆ ದಿನಾಂಕದಿಂದ. She was examined on 19/6, my lord. On the date she gives a complaint. ಆಮೇಲೆ ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಡಿಸ್ಚಾರ್ಜ್ ಮತ್ತೆ ಸ್ಟೇನ್ ಅಂತ ಇದೆಯಲ್ಲ ಸೊ
No, she was examined on
19/6, my lord.
2010.
ಹೌದು.
Date of offense?
25/4.
Naturally, there will not be any signs.
ಅಲ್ಲ ಅದಲ್ಲ ಸೊ ಅಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಪರೀಕ್ಷೆ ಮಾಡಿದ್ದು 19/6.
Yes.
ಪರೀಕ್ಷೆ ದಿನಾಂಕದಿಂದ 4 ದಿನಗಳ ಅಂತರದಲ್ಲಿ ಲೈಂಗಿಕ ಕ್ರಿಯೆ ನಡೆದ ನಿಶಾನಗಳು ಕಂಡು ಬಂದಿದೆ.
Yes. It was after a few months.
Yes, my
Date
lord.
of offense 25/4.
ಹೌದು.
Examined in June.
19/6. ಸೊ
quite
19/6 ಅಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಆದಾಗ ಜಸ್ಟ್ 4 ದಿನ ಹಿಂದೆ ಶಿ ಹ್ಯಾಡ್ ಇಂಟರ್ಕೋರ್ಸ್ ಅನ್ನೋದು ಗೊತ್ತಾಗಿದೆ ಅಂತ.
ಇಲ್ಲ ಇದೆಲ್ಲಿದೆ ಕ್ರಿಯೆ ನಡೆದ ನಿಶಾನೆಗಳು ಕಂಡು ಬಂದಿದೆ.
ಹಾ.
Okay.
ಜಸ್ಟ್ ಅದೇ ಪೇಜಲ್ಲಿ ಮೇಲ್ಗಡೆ ಡಿಸ್ಚಾರ್ಜ್ ಅಂತ ಇದೆ. ಅಂಶ ಕಂಡು ಬಂದಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆಮೇಲೆ ಡಾಕ್ಟರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಡಾಕ್ಟರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅದು ಯಾರ್ದು ಅಂತ ಹೇಳಿ ಏನು ಹೇಳಿಲ್ಲ ಅನ್ನೋದನ್ನ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
Yes.
My lord, in the charge sheet, my lord, ಬಗಿನಿ ಲಾಡ್ಜ್ ನಲ್ಲೇ ಆಗಿರೋದು ಅಂತ ಹೇಳಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರೋದು ಸುಮ್ ಈ ಅಫೆನ್ಸ್ ಆಗಿರೋದು.
As per the evidence of the victim.
ವಿಕ್ಟಿಮ್ ಕೂಡ ಅದೇ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ನಾನೇನ್ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಅಂದ್ರೆ ಚಾರ್ಜ್ ಮಾಡಿರೋದು ಸರಿ ಇಲ್ಲ ಅಂತ.
Why? Charge number 1 ಇದೆಯಲ್ಲ.
ಅದು 1 ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಇದೆ ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ 1 ಅಲ್ಲಿ ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ 420 ಅಂತಾನೆ ಚಾರ್ಜ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನೆಕ್ಸ್ಟ್ 1 ಡಿಸಾನೆಸ್ಟ್ಲಿ ಇಂಡ್ಯೂಸ್ಡ್ ಅದೆಲ್ಲಾನು. ಬಟ್ ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ 417ಗೆ ಮಾಡಿದ್ದಾರೆ. ಆಲ್ಟ್ರೇಷನ್ ಆಫ್ ಚಾರ್ಜ್ ಇಸ್ ನಾಟ್ ಮೇಡ್ ನೋನ್.
ಬೇಡ, 420 ಮಾಡಿದ್ದಾರೆ, 417 ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
Not made known to the accused.
You are knowing everything. You know what is the charge against you.
Bagini Lodge ಅಂತ ಏನ್ ಹೇಳ್ತಾರೆ, staff is not examined, Mazar is not
ಅದು
drawn.
ಬೇರೆ.
The Mazar witness, my lord, PW1. ಅದರಲ್ಲಿ 5ನೇ ಲೈನಲ್ಲಿ ಬೆಳಗ್ಗೆ 11 ಗಂಟೆಗೆ ನನ್ನ ಸಹಿ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಸ್ಥಳದಲ್ಲಿ ಪೊಲೀಸರು 2 ಗಂಟೆಗಳ ಕಾಲ ಇದ್ದರು. ಆ ಕಾಲಕ್ಕೆ ಚಾಸ 1 ಮತ್ತು 2 ಇದ್ದರು. ಚಾಸ 1 ಮತ್ತು ಆರೋಪಿಯು
ಮೆಟೀರಿಯಲ್ PW3 and 4 ಅಷ್ಟೇ ಅಲ್ಲ.
ಆಯ್ತು. ಇದ್ರಲ್ಲಿ ಒಂದೇ ಒಂದು ಚಾಸ ಇವ್ರು ಹೇಳೋದು ಯಾರ್ಯಾರು ಇದ್ರು ಆ ಮನೆಯಲ್ಲಿ ಅಂತ ಹೇಳಿ. ಆ ಮನೆಯಲ್ಲಿ ಈ ವಿಕ್ಟಿಮ್ ಇರ್ಲಿಲ್ಲ ಅನ್ನೋದು ಮಾಜರ್ ವಿಟ್ನೆಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಮಾಜರ್ ವಿಟ್ನೆಸ್ ಆ ಮನೆಯಲ್ಲಿ ಇರೋರೇನೆ. ಅಂದ್ರೆ ಅಲ್ಲಿ 3 ಮನೆ ಇರುತ್ತೆ. ಒಂದು ಮನೆ ಈ PW2 ಇರ್ತಾನೆ, ಇನ್ನೊಂದು ಮನೆ ಬಾಡಿಗೆಗಿರುತ್ತೆ, ಇನ್ನೊಂದು ಮನೆಯಲ್ಲಿ ಅವನಿರ್ತಾನೆ. ಸೊ ಈಕೆ ಆ ಮನೆಯಲ್ಲಿ ಇಲ್ಲ, ಬಟ್ ಮಹಜರ್ ಆ ಮನೆದ್ ಮಾಡಿದ್ದಾರೆ. Next, PW2 witness is Rajan, my lord.
ಅವೆಲ್ಲ ಸರ್ಕಮ್ಸ್ಟೆನ್ಷಿಯಲ್ ಬಿಡಿ, ಅದೇನಿಲ್ಲ. ಎಸ್, ವಾಟ್ ಈಸ್ why there was delay? Why no mahazar was drawn at the scene of occurrence? See, whether the incident had occurred in her house or in the lodge. ಎಲ್ಲಿದೆ ಚಾರ್ಜ್ನಲ್ಲಿ? ಎಲ್ಲಿದೆ ಅದು? ಚಾರ್ಜಲ್ಲಿ ಇಲ್ಲ. As per the charge, it is at Bagni Lodge. ಚಾರ್ಜ್ ಹೇಳ್ತಾ ಇದೆ, ಮನೆಯದ್ರ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ. Date of complaint ಯಾವಾಗ?
ಕಂಪ್ಲೇಂಟ್ ಬಂದು 19/6. Exhibit 1.
2010.
Exhibit P6. P6.
19/6/2010.
Yes, ma'am.
Complaint also there is no mention. Good. I'll allow their appeal. Hmm? Hmm. That is also against. That is also against the prosecution. According to her, he committed the offense till 18/4/2010. She was examined on 19/6. 19/6. How can there be such observation? Hmm? Something she was hiding. There must be some reasonable explanation. The appellant in SC 288 of 2012 is impugning the judgment of conviction and order of sentence dated 30th March 2013, convicting and sentencing him for the offense punishable under sections 376 and 407, and convicting him for the offense punishable under section 376 and 417 of IPC, and sentencing him to undergo rigorous imprisonment for 7 years, pay a fine of ₹50,000 with the default sentence, and for the offense punishable under section 417 of IPC to undergo rigorous imprisonment for 1 year and to pay a fine of ₹1,000 with the default sentence. The case of the prosecution in brief is that the accused had contacted PW victim, the PW3 over phone, and developed intimacy with her. He induced her by promising to marry, and committed forcible sexual intercourse with her from 2012-2009 to 23/12/2009, and from 17/4/2010 to 18/4/2010 in Bhagini Lodge at Marthahalli, and thereby committed the offence punishable under section 376 of IPC, and thereafter refused to marry her, and thereby committed the offence punishable under section 420 of IPC. After filing of the charge sheet, the trial court took cognizance of the offence and committed the matter to the Sessions Court. The accused had appeared before the trial court, pleaded not guilty, and claimed to be tried. The prosecution examined PWs 1 to 8, got marked exhibit B 1 to 1 to 9 in support of its contention. The accused had denied all the incriminating materials available on record in his statement under 313 of the IPC. It has not laid any evidence in support of his defense. However, he got marked exhibit D1 during cross-examination of PW2. The trial court, after taking into consideration all these materials on record, held that the prosecution is successful in proving the guilt of the accused for the offence punishable under section 376 and 417 of APC, and accordingly convicted and sentenced him as stated above. Being agreed by the same, the accused is before this court. Heard so and so. Very limited points of consideration. I answer to the other point in the affirmative for the following reasons. It is the specific contention of the prosecution that the accused induced the victim girl, examined as PW3, taken her to Bagini Lodge, committed forcible sexual assault, sexual intercourse by promising her to marry from 2012-2009 to 23/12/2009, and again from 17/4/2010 to 18/4/2010, and thereafter refused to marry her and thereby committed the offense. The materials on record discloses that Exhibit P1 is the maser drawn in the house of the victim. It is never the contention of the prosecution that the incident had occurred in the house of the victim, but specific contention case made out by the prosecution is that the offence in question was committed in Bagini Lodge, Marthalli. No maser whatsoever was drawn in the said lodge, and none of the witnesses from the said lodge were cited or examined as witnesses. Therefore, it is only the interested version of PW3, the victim, is available in support of the contention of the prosecution. Next, it is the specific contention made by the prosecution that the accused committed forcible sexual intercourse on the victim from 2012-2009 to 23/12/2009, and again from 17/4/2010 to 18/4/2010. The first information was came to the lodge belatedly on 25/4/2010. And the victim was subjected to examination by PW4 on 25/4/2010. Strangely, the report of the medical officer, Exhibit P3, discloses that there were signs of committing sexual intercourse on the victim about 4 days earlier to examination. There is no explanation whatsoever by the prosecution in that regard when it is specifically stated that the accused had committed sexual assault only till 18/4/2010. Next, when it is the contention of the prosecution that the accused committed sexual assault, sexual intercourse on the victim girl under promise to marry, the victim has cooperated with him from 2012-2009 till 2012-2009, and again and once again from 17/4/2010 to 18/4/2010. Victim is aged 19 years and she was a major. The accused was aged 22 years. Under such circumstances, the conduct of the victim in cooperating with the accused in commission of the sexual intercourse repeatedly against her wishes cannot be accepted. When the prosecution has not at all identified the place where the incident had occurred by drawing a maser and by examining any of the witnesses from the Athene Lodge, I am of the opinion that the prosecution has miserably failed to make out a case against the accused. The benefit of doubt will have to be extended to the accused, and he is entitled for acquittal. I have gone through the impugned judgment of conviction in the order of sentence. The trial court, after ignoring all these material facts and the inconsistency in the evidence of the victim PW3, proceeded to convict the accused for the offence punishable under section 376 and 417 of IPC. In view of the discussions held above, I am of the opinion that the impugned judgment of conviction and order of sentence is liable to be set aside. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Appeal is allowed. Fees is fixed at 10,000. Next, 30.
Serial number 25. CVP Putraju,
Wait.
connected matter.
Appeal is allowed.
Javides, amicus curiae.
Appearing for the appellant in criminal appeal number 1635, my lords. And
I am for 1641 in the appellant. Last occasion, on well, last since 120
Amicus
days.
curiae is
We'll
already
address the
appointed.
arguments.
Huh?
We'll address the argument today. Kindly permit me.
Amicus curiae is appointed, sir. Noting your absence. Huh? Yavudu?
this matter is connected with some other two petitions which were disposed on the last
Already
occasion.
disposed of. Okay.
And this appellant is accused number 6, my lords.
Yes, he is already appointed. Let him argue. Yes. So what? How much time we may require?
10 minutes, my lord. Already it has been disposed in earlier last occasion, my lords.
I'll take up at 2:30.
Please, my lords.
Yes.
Oblige.
ಇನ್ಯಾವುದಿದೆ 26.
Serial number 26. Sandesh P. Nadigar, Jayaprakash Reddy.
My lords, I was informed last night that the party intends to take NOC from me, my lords. A week's time may kindly be granted. He's coming to the office today.
Sorry. ಅದೇ ಬೇಲೆ 2023 ನಿಂದ ಇದೆ. I will dispose of. But
So 1 week's time, my lords. I was in,
not even an hour. ಇವಾಗಲೇ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ.
that's I was informed that the party wants to take NOC from me, my lords.
Submits the praise for time on the ground that the appellant wants to engage the services of some other advocate. The appeal was preferred under section 14A so and so of so and so seeking bail. The appeal was preferred on 16/3/2023. Two years have lapsed after filing the appeal, and the appellant is not interested in prosecuting the appeal. Appeal is dismissed. Appeal is dismissed. Next,
My lords, I'm ready to address the arguments on merits, my lords.
appeal is dismissed ಅನ್ನೋವರೆಗೂ you are waiting.
I'm ready, my lords. Since last date I was ready, but the party was,
Maybe you should have addressed the argument when I refused to grant time.
apologies, my lords.
Repeatedly you are asking time.
No, the party, my lords, he created a,
I don't know, sir. I am not concerned about all those things.
lords, I'm ready to address on merits.
Then
my lords.
argue, Kudi. Yes, who is this?
My lords, complainant's appeal, my lords. Challenging the order of discharge order, my lords.
Discharge.
Please, my lords.
Ah.
My lords, the offense, the complainant filed a private complaint, my lords, before the trial court. My lords, recording the evidence, my lords, hearing before charge, my lords, the trial court has discharged the accused, my lords, holding that
No, before framing charge, it recorded the evidence.
evidence is recorded, my lords.
Yes.
Lords, the offenses are, my lords, 143, 144, 323, 324, 504, 506, read with 149 IPC and 31 RS of SCST POA Act, my lords. Lords, the reasoning of the trial court for discharge, my lords, is at page number 24, para number 24, my lords. I may be permitted to read.
Para number?
24, my lords. So now it is very pertinent to note that Exhibit P8 complaint presented before this court indicated that the accused persons used to scold her, touching her caste and assault her and obstructing the use of road to their house. However, it does not show the specific date, time and place of the alleged incident, but at para 5 of the said complaint at Exhibit P8, it is contended that complainant approached the Chelur police station and registered the GSC number so and so dated 29/9/2020. However, police have not taken any action. So the NCR case registered before Chelur police station, and in that regard, the aforesaid exhibit P2 acknowledgement issued in the said case. However, on perusal of exhibit P1 and 2 and evidence of PW1 and 2, there are contradictory versions regarding the genesis of incident, place of incident. Further, early statement at exhibit P1 and statement recorded in P2 does not show the caste abuse, alleged threat posed, use of club by accused number 1 to assault against the PW1. The PW1 and 2 have materially improved their versions during the evidence in that regard also. Further, so far as the alleged hurt is concerned, there is no medical evidence placed. Though PW1 admitted to Chellur Government Hospital, under the said circumstance, the evidence produced by the complainant do not raise the presumption that accused persons have committed alleged offences as contended by PW1 and 2. But the aforesaid contradictory, inconsistent, improved version leads to reasonable doubt about the incident alleged. Thus, the evidence adduced by the complainant does not make out a prima facie case against accused number 1 to 11 for the alleged offence. Hence, this court cannot proceed to frame charge against accused number 1 to 11. Lords, the trial court says that, my lords, there is no medical evidence for the hurt, my lords. But the trial court has observed that the evidence of the statement of the complainant is recorded in the primary health center. Lords, the trial court has also observed that there was regular quarrel among the accused and the complainant regarding.
Immediately after the incident, you had been to primary health center.
Please, my lords.
What is the medical record?
The evidence for being admitted in the primary medical center is that the statement itself is recorded in the primary health center.
Maybe, sir. Why
Please.
you have gone to primary health center?
Pardon,
For a checkup, you have gone there.
please, ma'am.
Whether you are subjected to medical examination,
I was subjected, ma'am.
where are the materials?
The medical document is not produced, ma'am.
Correct.
Please.
Ah.
But there was
If you had gone there and subjected yourself for medical examination,
Please.
naturally there will be some document.
Please, ma'am.
Ah,
Let's
that was observed by the trial court. What is wrong in it?
let's exhibit P2 itself shows that my statement was recorded when I was admitted in the hospital, ma'am.
If you are admitted, there should be admission register extract.
Please,
There should be medical examination report. There must be wound certificate.
please.
Nothing is there.
The trial court has also observed that there was regular quarrel between me and the accused people, my lords, with regard to the usage of the pathway that leads to my house.
You have to go to the civil court. Aste, pathway ಬಗ್ಗೆ.
My lords,
Complaint is exhibit P1.
exhibit P1. my lords. P2 is the acknowledgement, my lords, that was recorded in the primary health center.
Recorded by whom?
Recorded by the police itself, my lords.
Who informed the police
My lords,
to come to the primary health center?
my lords, we had been to the Chellur police station, and when they refused to register an FIR and made it as an NCR, but the private complaint was filed, my lords.
Yeah, initially NCR was.
Initially, NCR was there.
That is why there are no medical records. That's it. That is the only conclusion that can be arrived at.
Lords, but the trial court has observed that the a complainant belonged to SC/ST community. my lords.
Maybe, sir.
There were frequent quarrels.
Yes, that will not invoke the penal provisions.
My lords, there is evidence of eyewitness PW3 as well, my lords.
How many witnesses are examined?
Three witnesses, my
Three
lords.
witnesses.
Please.
Ah.
Complainant, her husband, and eyewitness PW3, my lords.
Inconsistency. Noted. Okay. ಅದು respondent. ಬರ್ಲಿಕ್ಕೆ ಮಧ್ಯ. Yes, other matters. Yes. Huh? Serial number? ಏನಾಯ್ತು? ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಎಫ್ ಆಯ್ತು, ಅದು ಮಾಡಿಸಿ. ಯಾವ್ದ್ರಲ್ಲಿ ಆಗಿರೋದು? ಎಷ್ಟು ಜನ ಆಗಿದೆ?
Wait. Yes, madam. ಪ್ಯಾಟರ್ನ್ ಮಾಡಲ್ಲ ನಾವು ಕೇಳಿ ನೋಡಿ. ಹೀಗಿದೆ ಸರ್. ಒಂದು ಧಾರವಾಡದೊಂದಿದೆ ಮ್ಯಾಟರ್, ಅದಾಗಿದ ತಕ್ಷಣ ಅದಾದ್ಮೇಲೆ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ. ಇಲ್ಲ ತಗೊಂಡ್ ಬನ್ನಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ತಗೊಂಡ್ ಬನ್ನಿ ಮಾಡಿಸೋಣ. ಹೇಳಿ. ಅಂದ್ರೆ ಧಾರವಾಡದೊಂದು ಆಗ್ಬಿಡ್ಲಿ ಸರ್, ಆಮೇಲೆ ಸರಿ. ಸೌಮ್ಯ, ಅದ್ಯಾವ್ದು ಕೊಡಪ್ಪ, ಅದು ಸ್ಲಿಪ್ ಕೊಟ್ಲಲ್ಲ ವಾಪಸ್. ಸೌಮ್ಯ, ಆ ಸ್ಲಿಪ್ ಒಂದು ಡೇಟ್ ಮಿಸ್ ಆಗಿದೆ ಅಂತ ವಾಪಸ್ ಕೊಟ್ಟೆ ನಾನು ಅಷ್ಟೇ. ಅದರಲ್ಲೂ ಇರುತ್ತಾ ಎಷ್ಟು ಅದರಲ್ಲಿ 3 ಇರುತ್ತಾ? ಅದೇ ಡೌಟ್. ಅದಕ್ಕೆ ಡೌಟ್ ಬಂದಲ್ಲ, ನಿಮ್ಗೆ ಯಾವ್ದಾದ್ರು ಬರಲ್ಲ ಆಯ್ತಪ್ಪ ನಿಮಗೆ. ಆಯ್ತು. ಇದು ನಾನು ಮೇಡಮ್ ಸಾಫ್ಟ್ ಸಿಲ್ಕ್ ಕರ್ಕೊಂಡ್ಬರ್ತಾ ಇದ್ದೀನಿ ಸ್ಯಾರಿ. ಎಲ್ಲಿದೆ ಅಂದರೆ ಮಾಮೂಲಿ ನಮ್ಮದೇ ಮೈಸೂರು ಸಿಲ್ಕ್ ಕ್ರೇಪ್ ಸ್ಯಾರಿ. ಮತ್ತು ಯಾವಾಗಲೂ ಸಾಫ್ಟ್ ಇರೋದಿದ್ರೆ ಪೂಜೆ ನಿಮಗೆ ಪೂಜೆ ಮುಗಿಸ್ಕೊಂಡ್ಬಿಟ್ಟು ಮಕ್ಕಳು ನೋಡ್ಕೊಡ್ತೀವಿ ಅದರಲ್ಲಿ. ಅದರಲ್ಲಿ ಆಮೇಲೆ ಜಾಗ ಪ್ರೊಟೆಕ್ಷನ್ ಬಂದಿದೆ 6 ಜನ ಅದಕ್ಕೆ ಅದಕ್ಕೆ ರೂಮ್ ಎಲ್ಲಿ ಮಾಡಿರ್ತೀವಿ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ. ಇಲ್ಲ ಅಲ್ಲೇ ಈಗ ಟೈಮ್ ಪರ್ಮಿಟ್ಸ್, ಯಾಕಂದರೆ ಮುಂದೆ ಅಂತ ಡಿಸ್ಟೆನ್ಸ್ ತುಂಬ ಜಾಸ್ತಿ, ಅದಕ್ಕೋಸ್ಕರ ನಿಮ್ಗೆ ಲೇಟ್ ಮಾಡೋದು ಬೇಡ ಅಂತ. ಅದಿದೆ 14th ಅದು ಕೊಡ್ತಾರೆ ಇಲ್ಲ ಅಲ್ಲೇ ಹಾಕಾಗಿರೋದು ನೋಡಿ. ಇವತ್ತು ಮೇಡಮ್ ಹಾಕೊಂಡಿದ್ದಾರಲ್ಲ, ಇದನ್ನು ಕೊಟ್ಟಿದ್ದೀನಿ ಐರಾಗಿದೆ ಆಲ್ರೆಡಿ. ಚೆನ್ನಾಗಿದೆ. ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಏನಂದ್ರೆ ಕೇಸ್ ಅನ್ಕೊಂಡೆ ನನಗೆ ಸಿಕ್ಕಲು ಅವರು ಅದೇ ಪ್ಲಾನ್ ಅಂತೆ. ಸೊ ಈಗ ನಾನು ಕಂಫರ್ಟಬಿಲಿಟಿ ಸರ್ ಒಂದೇ ಒಂದು ಧಾರವಾಡದಿದೆ ಆಮೇಲೆ ಕುತ್ಕೊಂಡು ಎಲ್ಲ ಸುಖ ಅದೇ ಟೈಮ್ ಸಿಕ್ಕದೆ ಪ್ರಶ್ನೆ ಮಾಡ್ಕೊಳ್ಳೋಣ. ಟೈಮ್ ಸಿಗಲಿಲ್ಲ ಅಂದರೆ ನಿಮಗೊಬ್ಬರಿಗೆ ತುಂಬ ದೂರ ಆಗುತ್ತೆ. 8 to 9 hours ಆಗುತ್ತೆ ಅಂತ ಮುಗಿಸ್ಕೊಂಡು ಕರ್ದಿಲ್ವಲ್ಲ ಮೇಡಮ್. ತುಂಬ ಚೆನ್ನಾಗಿ ಮೇಂಟೈನ್ ಮಾಡ್ತಾರೆ. ಯಾರಿಗೆ ಬೇಕು ಅವ್ರಿಗೆಷ್ಟು ಬೇಕು ಅದು ಅವಾಗಿಂದಲೂ ಹೇಳಿದಂತ ಒಂದ್ಸಲ ಇವಾಗ ಸಖತ್ ಕೋಪ ಬಿಡೋದಿಲ್ಲ. ಕೇಸಲ್ಲಿ ಎಸಿದ್ರು ನಮ್ಗೆ ಏನೇನೋ ಹೇಳೋದಿರೋದು ಹೇಳ್ತಾ ಇರಲಿಲ್ಲ. ಅರ್ಜಿ ಕೇಳಿದ್ದೀನಿ ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಅವ್ರು ಕೇಳಬೇಕು. ಏನಂದ್ರೆ ಪೂಜೆ ಅದೇ ಅದು ಬೆಸ್ಟ್. ನನಗೆ ಕಾಟನ್ ಆಗಲ್ಲ ಯಾಕಂದ್ರೆ ಕೆಲವು ನೀವು ಹೇಳಿದಂಗೆ ಎಲ್ಲ ಕೂರಿಸೋದು ತುಂಬ ಕಷ್ಟ. ನನಗೆ ಅದೇ ಇಷ್ಟ. ಅದೇ ನಮ್ಮನೆ ಕಾಟನ್ ಥರ ದಪ್ಪ ಮಾಡೋದು ಚೆನ್ನಾಗಿ. ನಾವಿರೋದೇ 3 ಮುಖದಲ್ಲಿ ಬೇರೆ ಜನ ಜಾಸ್ತಿ ಇದ್ದರೆ ಹೆಲ್ಪ್ ಮಾಡ್ತಾರೆ. ಕಡಿಮೆ ಇರುವಾಗ ನಾನು ಅದು ಇದನ್ನು ಹೇಳಿದೆ ಇವಾಗ ಒಂದು ಸಾರಿ ಕೊಟ್ಟಿದ್ದಲ್ಲ ಅದು ರಿಟರ್ನಿಂಗ್ ಫಂಕ್ಷನ್ಗೆ ಹಾಕೋಣ ಅಂತ. ನ್ಯೂಸೇನೋ ಸರಿಯಾಗಿದೆ ಸಿಂಪಲ್ ಆಗಿ ನೀವು ಹೇಳಿದ್ಮೇಲೆ ಕೊಟ್ಟಿಲ್ಲ. ನಾನು ನಿಮಗೆ ತಗೊಂಡು ಕವರಲ್ಲಿ ಕಲರ್ ಅದೇ ಕವರಲ್ಲಿ ಅಲ್ಲೇ ಇಟ್ಟಿದ್ದು. ಏನಂದರೆ ಸ್ಟಿಚ್ ಮಾಡಿಸಿದ್ರೆ ಟಕ್ಕಂತ ಮಾಡಿಸ್ತೀನಿ. ಮಾಡಿಸ್ತಿಲ್ಲ ವರ್ಷಗಟ್ಟಲೆ ಮಾಡ್ತೀನಿ. ಈಗ ಮೊನ್ನೆ ಮಾಡಿಸಿದ್ರೆ ನನ್ನ ಫಸ್ಟ್ ಸೀರೆ ಕೊಟ್ಟಿರೋ ಸೀರೆ ಆ ಥರ ಮಾಡಿಸಿದ್ರೆ ಟಕ್ಕಂತ ಮಾಡ್ತೀನಿ. ಸೇಮ್ ಕವರಲ್ಲಿ ನೀರು ನಮಗೆ ನೆಕ್ಸ್ಟ್ಪೇಟಲ್ಲಿ ಬರುತ್ತೆ ಅದರಲ್ಲಿ ಮೆಸೇಜ್ ಅದಕ್ಕೆ ಎಸ್ ಮ್ಯಾಮ್. ಏನು ಬೇಕಿತ್ತು ಮ್ಯಾಮ್? ನೀವ್ಯಾರಿದೆ ಸರ್? Amicus curiae is appointed in this matter. It will be listed in the 3rd week of August. ಅದ ನಾಗೇಂದ್ರ ಅವರು ಹೈಕೋರ್ಟ್ ಅವರು ಲೀಗಲ್ ಮತ್ತೆ ಬಂದಿಲ್ಲ ಆದರೆ third week of August. ರವಿ ಧಾರವಾಡ ಕಳಿಸಿದ್ದೀವಿ. Eight hours. ಕಂಫರ್ಟಬಲ್ ಆಗಿ ದೇವಸ್ಥಾನಕ್ಕೆ ಹೋಗ್ಬೇಕಾಗುತ್ತೆ ಅಂತ ಮತ್ತೆ ನನಗೆ 12 hours 2 hours ಅಷ್ಟೇ. ಅದರಲ್ಲಿ ದೇವರು ನೀನು ಎಷ್ಟು ಈಸಿ ಹೋಗಿದ್ಯಾ ಅಂತ ಎಲ್ಲಾದರೂ Matter pertaining to Dharwad bench, serial number 1, Krishna S. Vyasa, Government Advocate, Rajendra Swami.
Appearing for the petitioner in this matter. Let's say the brief description about this matter is that, my lords, a complaint came to be filed against the petitioner on 14/6/2018, which came to be registered as, my lords, crime number 100/2018, my lords, which is as document number annexure A, my lords.
Of
Now,
which police station?
Of Kundugol police station, my lords. Kundugol police station, Dharwad district. Now, this complaint, my lords, is as an offshoot of an inquiry finding which was forwarded by the Lokayukta department to the Panchayat Development Authority, my lords. It is at page number 14, page at annexure B, my lords, is the complaint. The lordships may get the complaint. What it says is that the subject itself, Obba Shri Shekarappa Ramappa Marappanavaru, Kammadoli Ivaru, Shri A.H. Maniyar,
Page
Hindina
number?
PDO,
Page number?
page number 14, my lords, 14. ಹಿಂದಿನ ಪಿಡಿಒ ಕಮ್ಮದೊಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಹಾಗೂ ಸದರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿದ ಹಿಂದಿನ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀಮತಿ ಕತೂನ್ ಬಿ ಜಾಕಿರ್ ಹುಸೇನ್ ಗುಡಿಗೇರಿ ಕಮ್ಮದೋಳಿ ಹಾಗೂ ಇನ್ನು ಉಳಿದವರ ವಿರುದ್ಧ ಕಮ್ಮದೋಳಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ 13ನೇ ಹಣಕಾಸಿನ ಯೋಜನೆಯಲ್ಲಿ ಶೌಚಾಲಯ ನಿರ್ಮಾಣ, ಎಸ್ಡಿಎಸ್ ಗೋಡೆ, ಮಣ್ಣಿನ ಸವಕಳಿ ತಡೆಯುವ ಕಲ್ಲಿನ ರಚನೆ ಯೋಜನೆ ಕಾಮಗಾರಿಗಳನ್ನು ಕೈಗೊಳ್ಳದೆ ಸರ್ಕಾರದಿಂದ ಬಂದ ಅನುದಾನ ಹಣವನ್ನು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡಿದ್ದು ಅದೇ ಅಂತ ದೂರಿನನ್ನು ಸಲ್ಲಿಸುವಂತೆ ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರವರು 1 ಕರ್ನಾಟಕ ರಾಜ್ಯ ಬೆಂಗಳೂರವರು ದೂರಿನಲ್ಲಿದ್ದ ಹಣ ದುರುಪಯೋಗವಾದ ಬಗ್ಗೆ ತಮ್ಮ ಅಧಿಕಾರಿಗಳಿಂದ ತನಿಖೆ ಮಾಡಿಸಿ ತನಿಖಾ ವರದಿಗಳನ್ನು ಪಡೆದು ಅಪರಾಧಗಳ ಮೇಲೆ ಅಪರಾಧ ಸಾಬೀತಾಗಿದ್ದರಿಂದ ಅವರು ಶಿಫಾರಸುರನ್ವಯ ಕ್ರಿಮಿನಲ್ ಮೊಕದ್ದಮೆ ದಾಖಲಿಸಿಕೊಂಡು ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಳ್ಳುವ ಬಗ್ಗೆ. On this subject, my lords, a complaint came to be registered and an FIR in crime number 100/2018 came to be registered.
Yes.
Now, this FIR, my lords, resulted in 3 charge sheets being filed before this honorable court, before the courts, my lords, and 2 of these charge sheets, my lords, came to be quashed by this honorable court in connected matters on the pretext that the inquiry report, my lords, had been in favor of this accused, which is at annexure D 110, my lords. The predominant finding in the inquiry report is that what is alleged is between the year 2012-13, my lords, whereas accused has assumed charge of that position itself on 11/6/2013. Your lordships, my lords, through your orders dated 16th of April 2025, my lords.
Accused assumed charge on
11/6/2013, my lords.
13. This misappropriation?
These allegations are 2012-13 year, my lords. The finance, that is the 13th finance committee is for the year 2012-13, my lords. And even by going through the entire contents of the charge sheet, what is filed before the honorable court, my lords, one could find that there is no documentary evidence to support the case. Only the statements of witnesses have been taken. Even they do not allege anything which is perpetrated by this accused, my lords, because he was not in an incumbent official at all during that course of time. On this basis, my lords, your lordships, in your order dated 16th of April 2025, my lords, a copy is produced on the file of this honorable court. If not, I will provide another copy, my lords.
It is there.
It is there. Yes, my lords. I draw the attention of this honorable court too, my lords. Paragraph number, the reasons, 8, my lords. Paragraph number 8, page number 6.
Those are all facts of the case, I think.
Yes, my lords. The reasons attributed by your lordships, my lords. And paragraph number 13, my lords. 13. In the present case, It is not in dispute that the additional registrar of Karnataka Lokayukta held an inquiry against the petitioner, who is arraigned as accused number 2. The charges framed by the adjudicating authority and the allegations against the petitioner as per the charge sheet are one and the same. That is misappropriation of 62,000 withdrawn for construction of 14 lavatories, construction of the same, and withdrawal of 2,40,436 for construction of SDS protection wall, and misappropriating the same without construction of the wall. A specific finding was recorded by the adjudicating authority that the petitioner, who was working as PDO, had taken charge only on 11/6/2013. And the amount of rupees 62,930 has been withdrawn and paid to the police. Wrong on 5/4/2013, that is much before the petitioner took charge of the office as PDO, and is also the finding of the adjudicating authority that the SDS protection wall was in fact constructed, and with regard to the same, a sum of rupees 2,40,436 was withdrawn, and there was no misappropriation. When such categorical finding was recorded by the adjudicating authority, who is none other than the additional registrar of Karnataka Lokayukta, I do not find any reason to continue the proceedings initiated against the petitioner when there are similar allegations based on similar set of documents. The learned government advocates also contended that none of the charge sheet witnesses have been examined before the adjudicating authority, and the investigating officer has cited as many as 10 witnesses. Under such circumstances, the criminal proceedings cannot be quashed. Even though the investigating officer has cited as many as 10 witnesses in the charge sheet, none of these witnesses would speak specifically about the commission of offence by the petitioner. CW1 is the informant who lodged the first information against the accused 1 to 3 on the basis of recommendation made by Karnataka Lokayukta. CW2 and 3 are the Mahajar witnesses who stated regarding construction of so and so. CW4 and 5 have given service particulars regarding the accused. CW6 to 8 speak about construction of SDS protection wall. 9 is investigating officer who registered the FIR and conducted investigation, file charge sheet. Even if all the prosecution witnesses were to be support the case of the prosecution, the charge against the pretended petitioner cannot be said to be proved beyond the reasonable doubt. When adjudicating authority in the reported annexure D specifically states that the petitioner had taken charge of the office only on 11/6/2013, while the withdrawal of the amount so and so, no amount of evidence could help the prosecution to prove the guilt of the petitioner. Similarly, with regard to misappropriation so and so. And the lordships have come to a conclusion that, my lords, these proceedings are unsustainable in the eye of law. This charge sheet, my lords, on the earlier occasion was not produced before the by inadvertence, my lords. Another charge sheet was repeated in this paper book, my lords. So therefore, I was supposed to produce another charge sheet on record, which has been done so, my lords.
Now, who is the appellant here? Petitioner here?
Petitioner is the accused too, my lords. Same person. ಅವರ ಸಂಬಂಧದಂತೆ ಇವಾಗ ಏನು ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರಲ್ಲ, ದಟ್ ಇಸ್ ಇನ್ CC ನಂಬರ್ 122 ಅನ್ನೋದು. ಲಾಸ್ಟ್ ಟೈಮ್ ಈ 122 ಹಾಕೋದ್ರ ಬದಲು 121 ಬೈ ಇನ್ಅಡ್ವರ್ಟೆನ್ಸ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ರು ಆ ಫೈಲ್ ನಲ್ಲಿ. ಅದಕ್ಕೋಸ್ಕರ ತಾವು ಅದನ್ನ ರೀಪ್ಲೇಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಅಡ್ಜರ್ನ್ ಮಾಡಿದ್ರಿ ಸ್ವಾಮಿ ಮ್ಯಾಟರ್.
Now CC number 957 of 2023.
That is
file this.
Yes. It is a renumbered one, my lords. 122 has become 957. Sorry, rather it is the other way around, my lords. 957 has become 122/2019 on the file of Kundugold because court all change it.
No, earlier number 122/19.
ಅಲ್ಲ, ಇವಾಗಿನ ನಂಬರ್ 2019 ಪ್ರಕಾರ it is just a minute, my lords.
CC number 2957.
Yes, my lords. Yes. Earlier number was 122, but the present number is 957/2023. I plead apology.
Here the similar allegations.
Yes. Same complaint.
Now, what is the misappropriation? What is
the misappropriation ಅಂತಂದ್ರೆ ಇವರು ಏನು ಹೇಳ್ತಾರೆ ಅಂತಂದ್ರೆ, I draw the attention of this honorable court to the charge sheet column itself. ಮಾನ್ಯ ಘನ ನ್ಯಾಯಾಲಯದ ಕುಂದಗೋಳ್ ಪೊಲೀಸ್ ಠಾಣೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಕಮ್ಮಡೋಳಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಕಮ್ಮಡೋಳಿ ಗ್ರಾಮ ಈ ದೋಷಾರೋಪಣ ಪತ್ರ ಕಾಲಂ ನಂಬರ್ 12 ನಮೂದಿಸಿದ ಆರೋಪಿ 1ರವರು ಜನರ ಪ್ರತಿನಿಧಿ ಪಂಚಾಯಿತಿ ಅಧ್ಯಕ್ಷರಿದ್ದು, ಆರೋಪಿ ನಂಬರ್ 2ನೇದವರು ಸರ್ಕಾರಿ ನೌಕರರು ಪಂಚಾಯಿತಿಯ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಯಾಗಿದ್ದು, ಮೇಲಧಿಕಾರಿಗಳ ಅನುಮತಿ ಇಲ್ಲದೆ ಪಂಚಾಯಿತಿಯ ಮಾರ್ಗಸೂಚಿ ಆದೇಶಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಸರ್ಕಾರದ ಹಣ ರೂಪಾಯಿ 80,000ಗಳನ್ನು ಲಪಟಾಯಿಸುವ ದುರುದ್ದೇಶದಿಂದ ಪಂಚಾಯಿತಿ ಸದಸ್ಯರ ಸಂಬಂಧಿಕರಿಗೆ ಕಾಮಗಾರಿಯ ಕೆಲಸವನ್ನು ಕೊಟ್ಟು ಕಾಮಗಾರಿಯ ಕೆಲಸವನ್ನು ಮಾಡಿಸದೆ ಆರೋಪಿ ಆಪಾದಕರ 3 ರಿಂದ 6ರವರೆಗೆ ಪ್ರತಿಯೊಬ್ಬರಿಗೂ ರೂಪಾಯಿ 20,000ದ ಚೆಕ್ ಕೊಟ್ಟು ಕಾಮಗಾರಿಯ ಕೆಲಸ ಪೂರ್ಣಗೊಂಡ ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿಗಳನ್ನು ನಿರ್ವಹಿಸದೆ ಸರ್ಕಾರದ ಹಣ ರೂಪಾಯಿ 80,000ಗಳನ್ನು ಲಪಟಾಯಿಸಿ ಸರ್ಕಾರಕ್ಕೆ ನಂಬಿಕೆ ದ್ರೋಹ ಹಾಗೂ ಮೋಸ ತನಿಖೆಯಲ್ಲಿ ಸಾಬೀತಾಗಿರುತ್ತದೆ. is what they have sent. But throughout the charge sheet, my lords, there is not even a single piece of document that they have produced, even the check, because nothing has been issued by this accused.
How many witnesses are cited?
My lords, the same witnesses, same set of witnesses. Same set of witnesses. 8 witnesses, my lords, at page number 14 of the charge sheet.
Charge sheet witnesses ಎಲ್ಲಿದ್ದಾರೆ?
At page number 14 of the charge sheet, my lords. 14 ಅಂತ ಅದು ಏನು ಅದರಲ್ಲಿ
26 page number 26.
ಇಲ್ಲ 3 4th page by page, my lords. 4th page of the charge sheet.
Running page 26 ಅಲ್ವಾ?
ಅಲ್ಲ 14 running page to 14 ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. This would be the page, my lords.
ನಲ್ಲಿ ಫಸ್ಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಇರೋದು.
ಅಲ್ಲ charge sheet ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. Which has been produced along with the memo, my lords.
Crime number 100 of 2018.
Yes, ಇದ್ರದ್ದು ಬಂದು ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ನ ರಾಂಗ್ ಆಗಿ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ.
So ಇದಲ್ಲ.
ಅದಲ್ಲ. Charge sheet wrongly produced. Therefore, my lords, another copy has been produced. I am producing another copy for the note.
Wrong ಆಗಲಿ ಸೇಮ್ ಕಳಿಸಿದ್ರಿ ನೀವು ಕೂಡ.
ಇಲ್ಲ ಸೇಮ್ ವಿಟ್ನೆಸ್ ಇದೆ ಇದೇನೆ. Witnesses are the same, my lords.
Witnesses may be same. Even crime number 100 of 2018.
Yes, crime number is the same.
Then,
but either CC number is different.
okay, very same complaint. They have filed different.
3 charge sheets, my lords.
PW3 is the material witness for them. 3 to 6.
Yes, my lords. Your lordships may see at page number 21, my lords, it is CC number 121/2019 which came to be produced. It should have been CC number 122. ಅದನ್ನ ತಪ್ಪಾಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಚಾರ್ಜ್ ಶೀಟ್ ನ. ಅದಕ್ಕೋಸ್ಕರ ಮ್ಯಾಟರ್ ಹೇಳ್ತೀನಿ. The list of witnesses in this page at running page number 26, my lords. ಅದರಲ್ಲಿ ಸೇಮ್ witnesses ಇವರು ಕೊಟ್ಟಿರುವಂತದ್ದು.
Yeah, who is for the other side? Respondent.
Government.
ಯಾರಿದ್ದಾರೆ? ಯಾರು?
FCGP Harvard bench.
Harvard matter.
Paper.
Yes, sir.
Person, my lord. Charge sheet materials, my lord, against this accused, my lord.
No, you have heard his argument.
Trial.
Sir, you have heard his argument.
No, my lord, it's not connected properly.
You have to answer his submission, sir. He has raised certain queries. You have to answer that. It is not sufficient if you say charge sheet is filed against him, so dismiss. No. I'll pass over the matter. Please talk to him.
All copies have been provided to them, my lords.
Copy ಕೊಟ್ಟಿರ್ತಾರೆ ಮತ್ತೆ. You ask the learned counsel for the petitioner and answer his queries. I'll take up. ಅದು ಮಾಡ್ಕೊಳ್ಳಿ. Pass over.
Last one matter, Bangalore bench matter. Serial number 26, Sandesh P. Nadigar. Jay Prakash Reddy.
Appellant.
You are in there. Okay. Yes.
That's evidence of PW3, my lords.
What are the offense alleged? 323, 324,
Please, my lords.
ಇದೆ. But no document.
Medical document, my lords, with respect to 323 and 324.
Is it not necessary?
My lords,
Causing hurt.
my lords, when the sworn statement was recorded, my lords, the complainant has mentioned that she had handed over it to the police, my lords.
Where is it produced?
My lords, in the sworn statement, my lords.
It is not part of the charge sheet.
Exhibit P1, my lords, is the complaint that was given by the complainant to the police, my lords, on the date of the incident. It was not considered. Exhibit P2 is the
File
acknowledgement.
the private complaint.
Please, my lords.
Whether you have produced it along with the private complaint? No.
Complaint that was given before the police is produced, my lords. It is marked as Exhibit P1. Thereafter, Exhibit P2 is the endorsement issued by the police, my lords, about registering the NCR. Lords, while at the time of the sworn statement, the complainant has mentioned that she had given the medical records to the police, my lords.
That will not help you in any manner, sir. Even if you say before the trial court, what will happen?
Pardon me.
Can it be accepted during trial? How that will help you?
My lords, even if 323 and 324 goes, my lords, by SCST POA Act will remain, my lords. 3-1, the
That
trial
is what
court.
the trial court observed. There is no allegation that with an intention to humiliate you, your caste was referred to.
Lords,
You were abused by referring to your caste. That was the observation of the trial
Lords,
court.
evidence of PW3, my lords, who is an independent witness to the incident, my lords. She also has stated that the complainant was abused.
Complaint. Where is the complaint?
Lords, complaint is Exhibit P9,
You have
my
not
lords.
produced it.
Exhibit P9, my lords.
You have not produced it.
My lords, it's a appeal, my lords, so I can only produce judgment along with the appeal.
Only that. Sorry. Heard learned counsel for the appellant in part. Call for trial court. Yeah, since it is felt necessary to call for the trial court records for better appreciation of the contentions taken by the appellant, call for trial court records. Well,
Grateful.
yes. I think. Then next, list immediately after securing the trial court records.
Serial number 27, Kashinath JD, Ahmad Hassan.
The notes could Madeleine notes could.
This, my lord, in respect of
1 minute. Sir. ಇದು ಯಾವ್ದು ಇವಾಗ 27. Yes.
this, my lord, appeal is filed, the section 4, in in respect of discharge the accused, so far as, my lord, the provisions of the Atrocities Act under counsel,
Yes.
my lord. This, my lord, the impugned order is at
ಇದರಲ್ಲಿ
page,
ಇದು ಬೇಕಾಗುತ್ತೆ.
page 10, my lord.
You have produced all the materials,
Yes, my lord, I have, charge sheet is also produced.
produced
Charge sheet
whether
is
evidence was recorded, evidence of the
No, my lord,
witnesses?
it's pre-trial.
Discharge.
Discharge.
Yes.
Insofar as, my lord, POA Act, my lord, sections 3 subclass 2, 5 is concerned. Kindly, my lord, I will just charge sheet, my lord. Page 41, my lord, column 17 of the charge sheet. From bottom, page 41.
44.
Yes. May I read?
Yes.
ದಿನಾಂಕ 12/10/2021 ರಾತ್ರಿ 9 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಘನ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿಗೆ ಸೇರಿದ ಡಾಬಸ್ಪೇಟೆ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದು ನೆಲಮಂಗಲ ತಾಲೂಕು ಸೋಂಪುರ ಹೋಬಳಿ ಡಾಬಸ್ಪೇಟೆ ಟೌನ್ ಸಿವಿಜೆ ಶಾಲೆಯಲ್ಲಿ ಇರುವ ಸಾಕ್ಷಿ 23ರವರ ಬಾಪ್ತು ಗ್ರಾನೈಟ್ ಅಂಗಡಿಯಲ್ಲಿ ಈ ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿಯ ಅಂಕಣ 12ರಲ್ಲಿ ನಮೂದು ಮಾಡಿರುವ ಮುಸ್ಲಿಂ ಜನಾಂಗಕ್ಕೆ ಸೇರಿದ ಆರೋಪಿಯು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಆದಿ ಕರ್ನಾಟಕ ಜನಾಂಗಕ್ಕೆ ಸೇರಿದ ಮೃತ ಕೆಂಪ ಅಲಿಯಾಸ್ ಕೆಂಪಣ್ಣ ಮತ್ತು ಸಾಕ್ಷಿ 15, 16 ಮತ್ತು 17 ಜೊತೆ ಮದ್ಯಪಾನ ಮಾಡುತ್ತಿದ್ದಾಗ ಗ್ರಾನೈಟ್ ಅಂಗಡಿ ಎದುರಿಗೆ ವಾಸ ಮಾಡುತ್ತಿದ್ದ ಸಾಕ್ಷಿ 25ರವರು ಮೃತ ಕೆಂಪ ಅಲಿಯಾಸ್ ಕೆಂಪಣ್ಣನನ್ನು ಏ ಜುಟ್ಟು ನೀನು ಇವತ್ತು ಸಖತ್ ಖುಷಿಯಾಗಿದ್ದೀಯಲ್ಲ ಎಂದು ಕೇಳಿದ್ದಕ್ಕೆ ಏನಿಲ್ಲ ಪಾರ್ಟಿ ಇದೆ ಎಂದು ಹೇಳಿದ್ದು. ಆಗ ಸಾಕ್ಷಿ 25ರವರು ಏನು ನಂಗೇನು ಇಲ್ವಾ ಎಂದು ಕೇಳಿದಾಗ ಆಗ ಮೃತ ನನ್ನ ಹತ್ರ ಕಾಸಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ದು. ಆಗ ಸಾಕ್ಷಿ 25ರವರು ಮೃತನಿಗೆ 100 ರು ಕೊಟ್ಟು ನನಗೆ ವೋಡ್ಕಾ ತಂದು ಕೊಡು ಎಂದು ಹೇಳಿದ್ದು. ಆಗ ಮೃತ ಕೆಂಪ ಸಾಕ್ಷಿ 17 ಮತ್ತು ಆರೋಪಿ ರವರುಗಳ ಜೊತೆ ಸಾಕ್ಷಿ 15ರವರ ಬೈಕಿನಲ್ಲಿ ಡಾಬಸ್ಪೇಟೆ ವೀರಸಾಗರ ರಸ್ತೆಯಲ್ಲಿರುವ ಅಶ್ವಿನಿ ಬಾರ್ ಮತ್ತು ರೆಸ್ಟೋರೆಂಟ್ಗೆ ಹೋಗಿ ವೋಡ್ಕಾ ಮದ್ಯವನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾರ್ ಹೊರಗಡೆಗೆ ನಿಂತಿದ್ದಾಗ ಆರೋಪಿಯು ಮೃತನಿಗೆ ಹಮಾಮ್ನವರಿಗೆ ಯಾಕೆ ಎಣ್ಣೆ ತೆಗೆದುಕೊಂಡು ಕೊಡ್ತೀಯಾ, ನನಗೆ ಕೊಡು ಕುಡ್ಕೋತೀನಿ ಎಂದು ಜಗಳ ಮಾಡಿ ಮೃತನನ್ನು ತಳ್ಳಾಡಿದ್ದು. ಆಗ 17ರವರು ಅವರಿಬ್ಬರಿಗೂ ಜಗಳ ಬಿಡಿಸಿ ವಾಪಸ್ ಗ್ರಾನೈಟ್ ಅಂಗಡಿ ಬಳಿಗೆ ಬಂದು ಮದ್ಯಪಾನ ಮಾಡಿದಾಗ ಸಾಕ್ಷಿ 17ರವರು ತಾನು ಮನೆಗೆ ಹೋಗಬೇಕೆಂದು ಅಲ್ಲಿಂದ ಹೋದ. ನಂತರ ರಾತ್ರಿ 10:30 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಆರೋಪಿ ಮೃತನಿಗೆ ಯಾಕೆ ಹಮಾಮ್ನವರಿಗೆ ಎಣ್ಣೆ ತಂದು ಕೊಡುತ್ತಿದ್ದೀಯಾ, ಮದುವೆಯಾಗಿರೋ ಹೆಂಗಸರಿಗೆ ಇಟ್ಕೊಂಡಿದೆ ಎಂದು ಬೈದಿದ್ದರಿಂದ ಒಬ್ಬರಿಗೊಬ್ಬರು ಜೋರಾಗಿ ಬೈಯದಿದ್ದಾಗ 15 ಮತ್ತು 16ರವರು ಜಗಳ ಬಿಡಿಸಿ ಸಮಾಧಾನ ಮಾಡಿ ಸಾಕ್ಷಿ 15 ಮತ್ತು 16ರವರು ಅಲ್ಲಿಂದ ಹೋಗಿ ನಂತರ 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಪಾನಮತ್ತನಾಗಿದ್ದ ಆರೋಪಿ ಮೃತನಿಗೆ ಯಾಕೋ ಎಲ್ಲರಿಗೂ ಹಾಗೆ ಬೈದು ಕಳಿಸಿದ್ದು, ನಿಮ್ ಹಾಗೆ ಹೀಗೆ ಸಹವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೀಯಾ, ಮದುವೆಯಾದ ಇಟ್ಟುಕೊಂಡಿದ್ದೆ, ಕಿತ್ತೋದ ಜಾತಿ ಸೋನ್ಸು. This is, my lord, they ended in, my lord, the killing the deceased on that day. Both are, my lord, the resident of the same place, same village. They belongs to the same village. My lord, they are each other known. What about their residents? My lord? Kindly, my lord, in the order, the impugned order, where, my lord, by taken into note, my lord, paste.
Are there any eyewitnesses?
Eyewitnesses, my lord, it is referred to it.
Who is the complainant?
The appellant is the complainant, his brother.
He is not the eyewitness.
He is not the eyewitnesses.
Then
The sole ground for
are
discharging.
there any eyewitnesses to the incident? No.
It is, my lord, in the course of investigation, they are referred, some of the witnesses, my lord, that is.
No. Who speak about the utterance by the accused to invoke the special provisions?
I'm not.
There must be some specific
Yes,
evidence.
I'll just, my lord, tomorrow I'll just place the entire charge sheet. I have a copy of the charge sheet.
Sir, ಹೇಳಿ ನನಗೆ ಯಾರು ಅಂತ ನಾನು I
This
can
is-
make out.
Yes,
Where is the order discharging?
yes, my lord, page 10, my lord.
That is discharge only for the provisions of special enactment.
Yes, my lord.
Yes, ಅಷ್ಟೇ.
The findings-
Crux of the matter.
Yes,
ಅಷ್ಟೇ.
yes, my lord.
Who is the witness who speak about utterance
The
of those
reason
words?
for discharge, my lord, Kindly para 8 of the order.
ಏನಿದೆ?
This Lord saying that, may I read, my Lord?
Yes.
As rightly submitted by the learned counsel for the accused, merely because the deceased happens to be a member of scheduled caste, the offence under section 325 of the SC/ST POA Act 1918 would not get attract automatically. Our Honorable High Court in decision number so and so, referring to the amended provision to 32 held that order to attract the said offence, it requires to be proved that the offence has been committed on the ground that the victim being a member of scheduled caste or scheduled tribe, and in the absence of this material, merely because the victim happens to be a member of scheduled caste, automatically is not get attracted.
Yes.
This
That is the settled position.
settled position. In
Yes.
respect of this, my Lord, marital submission is section 8 of the Atrocities Act, Lord, pursuant to amendment to the POA Act 2016. Section 8.
That is presumption.
Presumptions. In respect to the third presumption, Lord, C. 8C. The accused was having personal knowledge of the victim or his family. The court shall presume that the accused was aware of the caste of the tribal entity of the victim unless the contrary is proved. Here in a case below.
See, to raise the presumption,
Yes.
basic facts are to be proved.
Yes.
Unless the basic facts are,
In the-
any material to prove the basic facts, you cannot rely on the presumption alone.
Here, my Lord, the presumption is facts is
Presumption will
Yes.
arise after you discharge your responsibility, your burden.
Prosecution.
There must be
Yes.
some material, basic material.
Here it's
Then only
here,
presumption.
my Lord. Here, my Lord, by taking the substance of the charge sheet.
Who speak about utterance of those words?
That
Who
I-
are the eyewitnesses?
That just, my Lord, I'll pass over, I'll place it, my Lord. Now we know.
ಹೇಳ್ಬೇಕು, ಅದಿಲ್ದೆ ಏನ್ ಮಾಡ್ತೀರಿ?
I'll just pass
That
it.
is the moot point.
Yes.
How many witnesses are cited?
It's my Lord.
43 witnesses ಇದ್ದಾರೆ.
Yes, my Lord.
ಅದ್ರಲ್ಲಿ ಯಾರು eyewitness?
I will just place it in a few minutes. Just pass over. I will just.
ಸರ್, ಇದು ಏನಿದು?
I'm apologizing
ಇದು
for this.
ಹೈಕೋರ್ಟ್ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್
No,
ಮಾಡೋ
I'm
ರೀತಿನ ಇದು?
I apologize for, I have not had charge
ಏನೋ
sheet.
ಗೊತ್ತಿಲ್ಲ, ಕೇಳಿದ ಕೂಡಲೇ ಪಾಸ್ ಓವರ್ ಅಂದ್ರೆ ಏನು?
I just, my Lord, missed the file. Just
Then why you started argument?
kindly, my Lord, pass over for this particular aspect, my Lord. I'll just 2 minutes only.
Without preparation, you address the argument.
I'm apologizing, my Lord. I'll place it, my Lord. Pass over.
Serial number 28, Abdul, 29, Prakash Singh, P. Prasanna Kumar.
ಏನಿದು? ಇಬ್ರು ಇಲ್ವಾ? Counsel for the appellant and respondent are absent, no representation. Next.
Serial number 30, A. Mahesh Chaudhary, P. Prasanna Kumar. Mahesh Chaudhary.
Your Lordship, I appear for the appellant in this matter.
Yes.
Lordship,
Who filed this IA 1 of 2024?
the respondent has sought for early hearing of the matter, Your Lordship.
Yes, respondent has filed. 30. State by? Then I will dismiss this IA. ಅಷ್ಟೇ ಆಯ್ತು. Learned special PP submits that the coordinate bench in a connected matter had stayed the judgment of conviction and order of sentence impugned in the present case. Hence, IA-1 of 2024 filed by the Learned Special Prosecutor for early hearing is dismissed. Hmm. Hmm. Hmm? Hmm. ಹ್ಮ್. ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ಡೇಟ್ ಯಾಕೆ ಸರ್? ಸ್ಟೇ ಆದಾಗ ಡೇಟ್ ಯಾಕೆ ಕೊಡ್ತಾರೆ? ಗೆಟ್ ದಟ್ ಸ್ಟೇ ವೆಕೇಟೆಡ್, ದೇರ್ ಆಫ್ಟರ್ ಮೂವ್ ಎನ್ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ ಮೂವ್ ಎ ಮೆಮೋ. Then argue the matter on merits. Take a final decision. ಇವತ್ತು ಮತ್ತಿನ್ನೇನು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದ್ದಲ್ಲಿ ಬಂದಿಲ್ವಾ? ಕಾಲ್ ಫಾರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್. Admission can it be admitted? ಇದ್ರಲ್ಲೇ ಸ್ಟೇ ಮಾಡಿದ್ದಂತಾರ? ಮತ್ತೇನು ಮತ್ತೆ ಬೇರೆ ಯಾವ್ದೋ ಹೇಳಿದ್ರಲ್ಲ? Only sentence is stayed, suspended. 24/11. The special prosecutor draws the attention of the court to the order dated 24/11/2023, where the impugned judgment of conviction and order of sentence is stayed till disposal of this appeal. The special prosecutor submits that the appellant, who is convicted in the present case, is now again involved in another case and still continues to be in service. Hence, there is urgency in the matter. Yes, when will you argue, appellant?
Your Lordship, a short date may be set for the hearing, Your Lordship.
No further will be given, sir. You should get ready to address the argument.
Any, Your Lordship.
Learned counsel for the appellant undertakes to address the argument. I will admit the appeal. There is urgency in the matter. Heard, learned counsel for the appellant, learned special prosecutor on admission. On perusal of the materials on record in the light of the impugned judgment and the grounds made out in the appeal, I find sufficient grounds to admit the appeal. Accordingly, appeal is admitted. Call for trial court records list for final hearing. Yes.
Serial number 31. Suyo Gerale.
Clear minutes. Appellant Minors has been convicted Minors for section 8 and Minors 75, 8 of POCSO Act and 75 of BNS Minors.
He was in custody or on bail?
He was on bail Minors. It is not mentioned in the judgment. I have got the certified copy of the bail order Minors.
Good. ಯಾವುದು ಕ್ರೈಮ್ ನಂಬರ್ ಇಲ್ಲ, ಸ್ಪೆಷಲ್ ಕೇಸ್ ನಂಬರ್ ಅಲ್ಲ, ಯಾವುದರಲ್ಲಿ ಇದಾಗಿದೆ? Special CC, okay. Special case number 166
Please.
of 2024. Yes, he was on bail. Heard the format ತಗೊಳ್ಳಿ. He was on bail during trial. Subject to conditions. IA1 of 2025 is allowed.
Great.
Yes.
Appeal may be admitted.
Yes, admitted ಅಂತ ಮಾಡ್ಕೊಳ್ಳಿ ಅದೆಲ್ಲ ಹಾಕಿ. Call for trial court records. Yes.
Great.
Serial number 32, Rajesh Chettigar.
I am for the appellant in this case, my lord. That is convicted under section 6 and 12 of POCS Act and 363, 376 of IPC, my lord.
Yes.
That during the trial, my lord, he was in bail. That's in page number 20, my lord.
Para number?
Para number 4, my lord. During the course of investigation and inquiry, the accused was in judicial custody till date, and then he was enlarged on bail, my lord.
Yes. Allowed. Subject to conditions. He was on bail during trial. IA is allowed. Will admitted as full ಹಾಕೊಳ್ಳಿ. Call for trial court records. Just ಅದೆಲ್ಲ ಆಗಿಲ್ವಾ? Issue notice. Respond. First year PP ಗೆ ತಗೊಳ್ಳಿ. Additional. Takes notice for respondent number so and so. Third on IA1 of 2025. ಅದೆಲ್ಲ allowed. Third so and so. On admission. Admitted. Call issue notice to respondent number 2. In the meantime, call for trial court records. Next.
Serial number 33, Vaidya Ravi Lakshmi Narayan.
Same for appellate, my lord. Lord, another 2 matters has been connected with this matter. It has been given a date for tomorrow, my lord. It was listed yesterday and my Friday, man.
Counsel for the appellant submits that.
Serial number 33 and 34, my lord.
ಅದು ಯಾವುದು ನೋಡಿ ಅವರಿಗೆ ಹಾಕಿ. So directed to take notice. Counsel for the appellant submits that criminal appeal number. In all 3 appeals.
4, my lord.
4.
Yes, my lord. I've been given the numbers also, my lord.
So and so are connected with the present appeal. Office is directed to list all these appeals together. Yes. 33 and 34. Yes, come on.
Much obliged, my lord.
35, Santosh Kumar MB.
That's appeal is filed by the accused number 1 and 2, my lords. That's first they were acquitted, my lords. Then in the appeal, my lords,
Notice for responding.
the offence punishable is, my lords, 323 and 225, my lords. Convicted for the offence punishable under section 323 and 325. Accused number 1, my lords. Accused number 2 is convicted for the offence punishable under section 427, my lords.
The appellant is
Lords, the accused number 1 and 2, my lords.
1 and 2.
1 and 2, my lords. Initially, they were been acquitted, my lords, in the trial, my lords. Later in appeal, my lords, they have been convicted, my lords.
Trial court acquitted.
Please, my lords.
Both the accused.
Both the accused, my lords. All the accused, my lords. Along with them, 4 more accused are the my lords. All the accused were acquitted, my lords. The victims preferred the appeal, my lords, before the appellate court. Here,
Criminal appeal ಯಾವುದು?
criminal appeal is at page 16. 16 is the trial court order, my lords. Lords, on the ground that the
You are on bail.
bail, I was on bail, lords.
ತಗೊಳ್ಳಿ. Additional SPP takes notice for respondent number 1. Third, on A1 of 2025 seeking suspension of sentence. It is noticed that initially the trial court acquitted the appellants and the co-accused for the offence under section 143, 147, 447, 323, 325, 427, 405, 404, 506, read with section 149 of IPC. However, when the state preferred an appeal in the criminal appeal number 10008 of 2023 on the file of the learned 5th additional district and sessions judge Tumkuru, sitting at Tiputuru, allowed the appeal in part and convicted the present appellants who are accused number 1 and 2. Two of the appellants were on bail. Considering the grounds charged in the memorandum of appeal, IA1 of 2025 is allowed. The order of sentence passed by the first appellate court against the appellant is suspended, subject to conditions. Admit Madi. Issue notice to respondent number 2 and 3. Call for trial court records. Yes.
Number 36, Kempraju.
Lords, I'm appearing for the appellant, my lords. The appellant is accused number 3. My lords, I'm convicted for 307 and sentenced to undergo imprisonment for 5 years, my lords.
Yes.
Lords, throughout the trial, I was on bail, my lords. I not misused my liberty.
Hold. Notice agida actually.
I'm producing the order sheet, my lord.
Notice agida. Agida. Heard so and so on IA1 of 2025 seeking suspension of sentence and for bail. He was on bail during the trial. Taken into conviction.
Lords, I'm producing the order sheet, my lords, of the trial court.
Oh, para number 3 note. Okay. 3 na. Put it. ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆಪ್ಪ?
It's page 3 in the order sheet, my lords.
That was 2019.
Yes, my lords. Throughout the trial period, I was present before the trial court. I have not misused my liberty.
Then why the trial court referred that he is in custody?
My lords, earlier Sessions Court has rejected my bail, my lords. Subsequently, I approached this honorable court.
Yes, ಇದು ನೋಡಿದ್ದೀರಾ? ಕೊಡಿ. ಅದರಲ್ಲಿ ಇದೆಯಲ್ಲ 1 to 3 are present ಅಂತ ಬರ್ತಾ ಇದೆ. Appellant being accused number 3 was on bail during trial. No allegation of misuse of Allah. I is allowed, subject to conditions. Next to further on admission, satisfied Allah admitted. Issue notice to respondent number. Rola. Sorry. Yes. Call for trial court records. List for final. Yes, I is allowed subject to conditions admitted.
Grateful.
Serial number 37, B. Latif.
Section 7 read with the 8 of Fox Act, and your sentence was suspended for a month.
Additional SPP takes notice for response.
The sentence was suspended for a month by the trial court now. Lord, during the trial he was on bail. Subsequently, after conviction also, sentence was suspended.
Whether it is referred to in the judgment?
Yes, I have an order sheet also.
Judgment ನಲ್ಲಿ ಹೇಳಿದಾರೇನ್ರಿ?
Judgment ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ.
ಹೇಳಿಲ್ಲ.
ಇಲ್ಲ, ಇಲ್ಲಿ ಇದೆ ಕಾಪಿ. Earlier, during the trial bail ಅಲ್ಲಿ ಇರೋದು ಹೇಳಿದ್ದಾರೆ. And subsequently sentence was
ಅದಿರ್ಲಿ bail ನಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿ.
that was there in the page number 2, date of release. Date of arrest and date of release.
Yes. Additional SPP takes notice for respondent. Heard so and so. I1 is of 2025 allowed, was on bail. Sole accused
Sole accused.
was on bail, subject to conditions. Heard on admission. Admitted. ಅದೆಲ್ಲ full ಹಾಕಿ. ಬೇರೆ ಇದಾರ private respondents.
ಇದಾರೆ second.
Call for trial court records. Yes.
IM.
IA is allowed, subject to conditions. Appeal is admitted. Issue notice to private respondent. Call for trial court records.
Serial number 38, K. Murthy.
Lord, I appear for a appellant.
Additional SPP
The
takes notice.
accused has been convicted for the offence under section 6 of Fox Act and 376(2)(n of IPC, my lord. And throughout is in JC, my lord.
Then
Notice.
on merits sustain.
Yes.
Suspension baral. Heard Leonard, counsel for the appellant Leonard. Additional SPP for respondent number so and so. On I1 of 2025 seeking suspension of sentence and for releasing the appellant on bail. Materials on record discloses that serious allegations are made against the appellant and he is convicted for the offence punishable under section so and so. Admittedly, the appellant was in custody since 6/3/2023, that is during trial. Under such circumstances, I do not find any reason to release the appellant at this stage when he is already convicted by the trial court. Hence, I1 of 2025 is dismissed. Where is there a private issue notice to respondent number 2. Call for trial court records. List. Admit party. Appeal is admitted.
Yes, ma'am.
Call for trial court records. Next. Huh? ಯಾವುದು 30?
36. Temperature. In the first page itself, your lordship, it shows that accused number 1
Line
is
is
in
over.
JC, accused number 3 is in JC, and accused number 2 is on.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಏನೋ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ಲ ಅದೇನು ಮತ್ತೆ
Lordship, on page number 6, it says that accused number 1 to 3 present, counsel for counsel filed wakalat along with bail application for A2 file. Wherein A2 was granted clear the free trial stage on the basis of the bail granted by the honorable court.
ಅದಾಯ್ತು. Even subsequent order sheet also discloses accused number 1 to 3 present. ಇದೇನು ಕ್ಯಾನ್ಸಲ್ ಆಗಿದೆ ಬೇಲ್ ವಾಸ್ ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೆ ರಿಲೀಸಿಂಗ್ ಅಮ್ ಆನ್ ಬೇಲ್ ಸಿ PW accused number 1 to 3 are present ಅಂತಂದ್ರೆ ಮತ್ತಿನ್ನೇನು
Sureties by name so and so express their willingness to stand as surety for 8 million.
ಹಾ ಶೂರಿಟಿ ಯಾವಾಗ ಅಡ್ಮಿಟ್ ಮಾಡ್ತಾರೆ
Shows regarding 8 million. Office is directed to take.
ಇಲ್ಲ ರೀ ಇಲ್ಲಿ ನೋಡಿ ಇಲ್ಲಿ NBW issue NBW against accused number 2 and 3 with notice to surety. The next day petition under 72 of CRPC NBW recalled. Thereafter accused number 1 to 3 are present. Criminal petition 9158 of 2018. Accused number 3 is enlarged on bail. Page number 2 nalliddenu. 31/1/2019. Accused number 1 and 3 were granted bail by the Honorable High Court.
Past over matter, serial number 3, serial number 2, Gaurav Subramanian, I can take it. Sorry. Serial number 3,
And for the petitioners,
Madhavmurthy.
yeah. That process is ready. I will submit in the counter.
First ಕೊಡಿಯಲ್ಲಿ.
Continue, sir. Process has been paid.
Acknowledgement.
It is paid. But I could not able to submit in the counter because of long queue.
ಮತ್ತೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ?
That process paid, but regarding documents, I could not able to furnish.
Counsel for the appellant submits that he has paid the process for issuance of notice to respondent number 2 in the counter today. Office to verify. If PF is paid, issue notice to respondent number 2. Next.
Serial number 4 is Balakrishnan.
ಕೊಟ್ಟಿದ್ದಾರಾ? Counsel for the appellant submits that he has paid PF with copies of appeal memo for issuance of notice to respondent number 2. Office to verify. If PF is paid, issue notice to respondent number 2. Next.
Serial number 5, Rents Perve Tritesh.
They same.
Past over matter, serial number 27, Kashinath JD. Amadesan.
ಇದು ಒಂದೇ ಇರೋದು. Yes.
Yes. In this, my lord, in respect of the incident, there are three stages, my lord, took place on that day. One is, my lord, the first, they are doing some party, my lord, they are taking alcohol, and they went to, my lord, to buy further alcohol for this Jabi. And then, my lord, some galata was happened. In respect of this galata, my lord, happened earlier to the killing of this deceased. This, my lord, the incident is witnessed by, my lord, CW 15, 16, 17, 19, 20, and 25. CW 15, 16, 17, 19, 20, and 25.
They are the eyewitnesses.
The eyewitnesses to the galata which is happened at 10:30.
That is the first
The same day, the first galata.
incident.
The second incident after buying of alcohol from the shop.
That is second incident.
Second incident.
It is not the contention of the prosecution that you are abused by referring to your his caste.
In the second incident.
Second incident.
Yes.
Complaint ಎಲ್ಲಿದೆ ನೋಡಿ. Complaint ಎಲ್ಲಿದೆ?
Complaint is, my lord, he is not witness to the spot.
ಆಯ್ತ್ರಿ, ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ ಏನ್ ಹೇಳಿದಿರಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು.
Kindly ಅವನು ಯಾರು ಮಾಡಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ, someone has killed ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ದಾರೆ. Page bro in the 30C.
Charge sheet 17 ನಲ್ಲಿ ಅವರು ಓದಿದ್ರಲ್ಲ, ಎಲ್ಲಿದೆ ಪೇಜ್?
Page 44. It's 43 onwards.
First incident ಯಾವಾಗ?
It is, my lord, at about, my lord, it's 9:45 onwards, my lord, as per the witness statements. Then, my lord, next incident is 10:30. The death, the killing, my lord, it's after 11. This, my lord, 10:30 incident
See,
is.
offense under special enactment is at 11 p.m.
It is, my lord, it is connection to the death because.
Connection ಇರ್ಲಿ ಸರ್. ಬೈದಿದ್ ಯಾವಾಗ? ನಿಮ್ ಜಾತಿ ಎತ್ತಿ ಬೈದಿದ್ ಯಾವಾಗ?
5 ಬೈದಿದ್ದಲ್ಲ. Kindly, my lord, just.
ನೀವು ಅದನ್ನೆಲ್ಲ ಇಟ್ಟಿರಿ. ಫಸ್ಟ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ನನಗೆ.
3-2.
ಮಾತ್ಮಾತಿಗೆ ಅದನ್ನೇನು ಎತ್ತೀರಿ?
3-2V, my lord.
I know that.
Yes, my lord.
You have to bring it within that purview.
Yes, my lord. I'm not.
Facts ಹೇಳಿ ನನಗೆ.
Kindly, I'm sorry. Kindly, my lord, it's 2-3.
Don't be over excited.
No, my lord, I'm sorry.
Yes.
I'm sorry, my lord.
Facts ಮೇಲೆ ಕರೆಕ್ಟ್ ಇದ್ರೆ you are entitled for the relief. Otherwise, you are not.
Yes. 9:45, my lord, the first incident.
Yes.
It's on 10:30, my lord. There is an incident wherein, my lord, it's ಅದು I'll read, my lord, the entirety in it.
ಈಗ ಒಂದ್ಸಲ ಓದಿದ್ರಲ್ವಾ?
ಅದರಲ್ಲಿ
ಅದು ನನಗೆ ಅರ್ಥ ಆಗಿದಲ್ವಾ?
fourth line, my lord. Onwards, ಅವರು they come back from the restaurant
And then my lord, Galata has happened. And the next incident after 11 o'clock, in respect of that, my lord, these adjacent, these witnesses.
Simple question, you bala id madbedi. I can understand. The allegation that the offense under special enactment was committed at 11 p.m. Are there any witnesses to that incident? Earlier 9:45 ga hakiddu, 10:30 ga hakiddu. At present, I am not concerned. There is no allegation of abusing you, referring to your caste with an intention to humiliate, either at 9:45 or at 10:30. It is the specific contention prosecutionally at 11 p.m. when the incident had taken place. He referred to your caste, abused you with an intention to humiliate. Are there any eyewitnesses to that incident which had taken place at 11 p.m.?
That is, my lord, by taken that incident only, they connected this Jabi was committed. The
Adukenu eyewitnesses beda, we can presume antana.
The prosecution will what exactly?
Sorry. ಏನು ಇಲ್ಲ ಬಿಡಿ ಕರೆಕ್ಟ್ ಇದೆ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ ಅವ್ರದ್ದು ದಟ್ ಈಸ್ ವೈ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡಿಸ್ಚಾರ್ಜ್ ಅಷ್ಟೇ 302 ಇದೆ ಯು ಪ್ರಾಸಿಕ್ಯೂಟ್ ದಟ್ ಹೈಯೆಸ್ಟ್ ಅಫೆನ್ಸ್ ಇದೆ ಈವನ್ ಯು ಕ್ಯಾನ್ ಸೀಕ್ ಫಾರ್ ಡೆತ್ ಪೆನಾಲ್ಟಿ ಇದಕ್ಕೇನು ಇರಲ್ಲ ತಗೊಳ್ಳಿ ಅದೇನಾರು ಇದೆಯೇನ್ರಿ ಮತ್ತೆ ಅಷ್ಟೇ ತಾನೆ third so and so the first the appellant being the informant in special case 902 of 2021 is impugning the order dated 13th April 2023 passed under section 227 of CRPC discharging the respondent accused for the offence punishable under section 3(2)(v) of SCST Prevention of Atrocities Act 1989. While assigning the case to the appropriate court to try the respondent accused for the offence punishable under section 302 of IPC. Heard so and so. Here is the materials on record. Point for consideration. My answer to the above point in the negative for the following reasons. It is the contention of the prosecution as per column number 17 of the charge sheet that on 12/10/2021 the first incident had taken place at 9:45 p.m. in the matter of bringing liquor as the accused had insisted the deceased to bring the liquor. Later at 10:30 p.m. the accused had again referred to the deceased and insisted him to bring liquor and also abused him about his relationship with other women. CW 15 and 16 have came to the spot and pacified the situation. It is the further contention of the prosecution that at 11 p.m. the accused, who was fully drunk, came to the deceased, abused him in Hindi language by referring to his caste with an intention to humiliate him. And later he slapped the deceased. As a result of which he fell down on a granite slab, sustained fatal injuries and died. On going through the charge sheet, it is clear that CW 15 and 16 are the eyewitnesses to the second incident that had occurred at 10:30 p.m. CW 17 is the eyewitness to the first incident that had taken place at 9:45 p.m. But there are no eyewitnesses to the incident that had taken place at 11 p.m. when it is the contention of the prosecution that the accused had abused the deceased, referring to his caste, and humiliated him humiliated him. Under such circumstances, there are no witnesses to speak about the commission of the offence under the special enactment by the accused. Taking note of the same, the trial court proceeded to discharge the accused for the offence punishable under section so and so and so, under 5 of ACST. I do not find any illegality or perversity in the order passed by the trial court. As under section 227, the court is required to consider the records of the case and the documents submitted therewith. Here in the submissions of the accused and the prosecution finds that there are no sufficient grounds for proceeding against the accused, he shall be discharged. In the present case, except the say of the informant, who is admittedly now the eyewitnesses to the incident where the offence under section 3(5) of SC/ST Prevention of Atrocities Act has been committed by the accused, as states about the same, but none of the other witnesses speak about such offence, and under such circumstances, the contention of the prosecution that the accused has committed the offence under the special enactment cannot be accepted. Hence, I do not find any reason to interfere with the order passed by the trial court. Accordingly, I answer the above point in the negative and proceed to pass the following. Appeal is dismissed. Yes.
Matter pertaining to Dharwad bench. Government advocate.
ನಾಳೆ 10:30 ಆಗಲ್ಲ.
My lords, if given a minute, my lords, I will brief the government advocate.
ಮಿನಿಟ್ ಏನು ಈಗ ಇಷ್ಟೊತ್ತೇ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮ್ಗೆ.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ, ನಾನು ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ದೆ ಲೈವ್ ವಿಚಾರಕ್ಕೆ ಬಂದು ನೋಡಿ ಅಂತ.
ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಅವರು.
ಕನೆಕ್ಟ್ ಆಗಿಲ್ವಾ?
There is some connectivity.
Convenience of this honorable court.
Day after tomorrow.
Much obliged.
Day after tomorrow, Thursday. Yes, 2:30. Yes. Please inform him.
Yes, madam.
The grounds urged by him.
You know, I have appraised him about the grounds, my lords, as well as I have brought his notice the other petition which has been allowed.
Yes.
However, ಅಲ್ಲಿ problem ಏನಿದೆ ಅಂತಂದ್ರೆ, on each and every date there are different persons who are being interested. And they don't.
That is their problem.
Yes,
Let us not worry about that.
Yes, please.
Yes, ಆಯ್ತು ಮತ್ತೆ ಯಾವುದು?
Matter pertaining to Bangalore bench, serial number 25. Javid S.
Yes.
Hearing for the appellant, my lords.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲ 10 ನಿಮಿಷದಲ್ಲಿ ಮುಗಿಸ್ತಾರೆ ಅವರು.
Already these two petitions.
Connected matters are already disposed of.
Please, my lords.
ಈಗ ಇದು 2 ಇದೆ, ಅದರಲ್ಲಿ ಏನಿದೆ? ಕರೆಕ್ಟ್, 2 ಆಲ್ರೆಡಿ ಡಿಸ್ಪೋಸ್ ಆಗೋಗಿದೆ. ವಾಲ್ಯೂಮ್ನಸ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ವಾಲ್ಯೂಮ್ನಸ್, ಮೆಟೀರಿಯಲ್ಸ್ ಇರೋದು ವೆರಿ ಫ್ಯೂ ಮೆಟೀರಿಯಲ್ಸ್. ಅಷ್ಟೇ ಅದರಲ್ಲಿ ಇರೋದೇ ಅಷ್ಟೇ. ನೀವು ಈವನ್ ಇಫ್ ಯು ಗೋ ಥ್ರೂ ದಿ ಎಂಟೈರ್ ರೆಕಾರ್ಡ್ಸ್, ಯು ಮೇ ನಾಟ್ ಫೈಂಡ್ ಎನಿಥಿಂಗ್. ಕರೆಕ್ಟ್. When the accused are not identified.
Identified, my lords.
ಇದರಲ್ಲಿ ನೋಡೋಣ, ಅದಿದ್ರೆ ಆಯ್ತು.
Only on the quantum of sentence it was modified, my lords, partly allowed, my lords. Earlier two petitions, my lord. Even this appellant is also selling in the same accused.
Argument only, you are restricting only to modification of sentence.
Please, my lords, because since from past 7 years, 4 months he is in custody, my lords.
ಅದೇ ನೋಡಿ ಅಷ್ಟೇ ಮತ್ತೆ
Earlier petition also was quantum was reduced, my lords.
ಸೊ ಸಿಮಿಲರ್ ಆರ್ಡರ್ಸ್ ಅಷ್ಟೇ ಮತ್ತೇನು ಏನು he is convicted for ಇದು ಯಾರು ಅಪಲೆಂಟ್
Accused number 6, my lord.
ಒನ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 1641
1635, my lords. 1635.
accused number
6.
and 1641
41 accused number 9, my lords. Is little bit different, my lords.
accused number 9
9, my lords. He is convicted only for the offense under section 201, my lords. He has received the gold ornaments and melted to ingots, my lords. Converted to ingots. He is convicted for 201 for 3 years punishment, and he was in custody for 360 days, my lords. Nearly 1 year, my lords.
accused number 9
9, my lords.
what is the sentence
3 years, my lords.
3 years
3 years for 201, my lords.
he is a goldsmith
He has received the gold ornaments from the accused number 1 and converted the same into ingots, my lords.
then what about a6
A6, my lords. There is a recovery against by him, my lord. The
offense ಏನೋದು
he is convicted for offense punishable under section 120B, read with 149. 10 years, my lords. 10,000 fine.
be read with
149. And 395 read with 149. And 397 for 7 years. Maximum punishment is 10 years, my lords, for 120B and 395.
10 years each
Please, my lords.
397 7 years
7 years, my lords. 10,000 fine, my lords.
how many years he was in custody
7 years, 4 months, my lords.
in custody
Please, my lords. It is observed in the judgments, judgment also, my lords.
yes but he is liable what, 2.5 years maximum sentence, 201 again.
Please, my lords. There he has punished for 3 years, my lords. 1/4 of the maximum punishment.
1/4 of the longest.
Longest punishment.
That comes to 2.5.
2.5, my lords.
But
Not
he was in custody only 360 days.
360 days, my lords.
Yes. Let him serve the remaining sentence.
Not so. Can we impose on fine and set?
Fine ಎಷ್ಟು ಹಾಕಿದ್ದಾರೆ? What is the fine imposed?
3,000, my lords.
ಅಷ್ಟೇ. You don't know whether he is in a position to pay the fine or not. ಅದು ಯಾಕೆ ಮಾಡಬೇಕು? He is in custody now? No.
No, my lords. He is in bail, my lords. By this honorable court in this appeal, my lords.
Yes. We are not disputing the conviction, madam. He is only speaking about the sentence. ಅದನ್ನ ಯಾಕೆ ಐಡೆಂಟಿಫೈ ಮಾಡಿದಾರ ಬಿಟ್ಟಿದಾರ? We are not considering that. He is already underwent a sentence according to him 360 days. Maximum sentence is 2.5 years. No minimum. Accused number 9. So what should be the sentence? Set off ಕೊಡ್ಬೋದಾ? Only 201. ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ. ಫೈನ್ ಅಮೌಂಟ್ ಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡೋಣ. $10,000. Let him pay. About 6.
My lords.
ಏನು?
He has, there is a recovery from him, my lords.
ಅದು ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ ಇದೆ ಅವರು.
Please, my lords. Same, similar as accused number 1, 3, 5 and 7, my lords. Along with him, he has recovered 2 motor vehicles, my lord.
Similar with accused number 1.
Accused number 1, 3, 5 and 6.
ಮೊನ್ನೆ ಡಿಸ್ಪೋಸ್ ಆಗಿದ್ದು?
Please, my lord. Accused number 3 and 2, my lords.
2.
Please, my lords.
So
even he has accompanied with the same accused inside the house, my lord. Yeah.
Similar to that of accused number 3, he will be convicted.
Please, my lords.
ಅದು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ?
No, my lords. Still it is not ready, my lords.
A3 ಗೆ ಏನು ಹಾಕಿದಾರೋ ಅದನ್ನೇ. ಓಕೆ,
ಪ್ಲೀಸ್
ತಗೊಳ್ಳಿ. ಇದು serial number 25. What is this? Accused number 9. Convicted for the offence punishable under section 201. What is the sentence? 3 years.
3 years, my lord.
He is sentenced to undergo
3 years, 3,000 rupees.
Simple and ನೋಡ್ಕೊಳ್ಳಿ. 3 years sentence and to pay fine of rupees 3,000. Learned counsel for the appellant, amicus curiae, restricted his argument only regarding sentence and contending that he was in custody for 360 days. Next, offense under section 395, maximum sentence 10 years. Offense under 397 shall not be less than 7 years. Offense under 201, maximum 1/4 of the longest sentence. No minimum sentence is prescribed. Taking into consideration the nature of the offense alleged against the present appellant, I am of the opinion that while confirming the judgment of conviction, order of sentence may be modified as under modified accordingly. I answer the above point partly in the affirmative and proceed to pass the following. The appeal is allowed in part. Judgment of conviction sentencing appellant accused number 9 for the offence punishable under section 201 is confirmed The order of sentence passed by the trial court is modified as under. Appellant is sentenced to undergo simple imprisonment for a period of 1 year and to pay fine of ₹10,000 and in default to pay fine to undergo simple imprisonment for 3 months. The appellant is entitled for set off. Next, in 1635 ನಲ್ಲಿ the appellant is accused number 6, convicted for the offence punishable under section 120B, 395, 397, read with 149 of IPC. He was sentenced to undergo imprisonment for a period of 10 years each for the offence under 120B and 395 of IPC, and to undergo imprisonment for a period rigorous simple and 397 7 years with fine of so and so. It is stated that the accused number 6 who is the appellant hearing, he is still in custody.
Please, Lord, he is in custody.
He is in custody since 7 years 4 months. 4 months. The materials on record discloses that he is discloses that the allegations against the present appellant is similar to that of accused number 3, who was the appellant in criminal appeal number so and so, which was disposed of with the order dated so and so. Considering the same, similar relief could be granted in favor of the present appellant accordingly. Partly arithmetic. ಅದರಲ್ಲಿ ಏನಿದೆ ನೋಡ್ಕೊಂಡು ಹೋಗಬೇಕು. ಏನು ಅದೆಲ್ಲ ಅದೇ ಕನೆಕ್ಟೆಡ್ ಇದೆಯಲ್ಲ ಎರಡು ಕನೆಕ್ಟ್. ವಿಚ್ ಆರ್ ದೋಸ್ ಕನೆಕ್ಟೆಡ್ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ಸ್?
1634 of 2018 and 1026 of 2018.
Date of disposal
36/2025.
ಅದು ನೋಡ್ಕೊಳ್ಳಿ ಯಾರು ಮಾಡಿದ್ದು ಅಂತ. ಎರಡು ಪಾರ್ಟ್ಲಿ ಅಲ್ಲ.
Yes.
Both those appeals were allowed in part, is it?
Allowed in part, my lords, by modifying the sentence, my lord.
10,000. ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿ 10,000 ಒಂದರಲ್ಲಿ ಅಷ್ಟೇ. ಕಾಮನ್ ಆರ್ಡರ್ 10,000 ಒಂದೇ ಇದ್ರೆ ಹೌದು. ಎಸ್, ಫಸ್ಟ್ ಲಿಸ್ಟಿಗೆ ಬಂದರೆ ಬರೋದಿಲ್ಲ, ಅದ್ರ ಬರಲ್ಲ. ಕಸ್ಟಡಿ ಮ್ಯಾಟ್ರ್ ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ.
Please, my lord.
Why you are not appearing when the matter is called?
My lord appeared, my lord, but it's not visible, my lord. Not hearing, my lord, properly.
Sorry.
I have asked, my lord, taken on the last occasion, my lord, lordship passed the order. Just I have received, my lord.
Okay. When will you argue?
My lord, day after tomorrow, my lord, earlier my occasion, my colleague has appeared in this case, my lord. He is argued this case, my lord. I will hand
Yes.
over, my lord. This,
Either you argue the matter or ask your
Please,
colleague
please,
to address the argument.
please, my
If
lord.
both of you remain absent, I will proceed to pass orders.
Please, ma'am. I
I
will,
will wait. I will
promise,
not
ma'am.
wait further.
Please, ma'am.
Day after tomorrow at 2:30.
Please, grateful.
Yes.